Good morning. Welcome to the July 24th, 2025 meeting of the California Privacy Protection Agency Board. We are meeting in San Francisco, and I'm pleased to be here with my fellow board members in person and members of the public, as well as those joining us via Zoom and members of our fantastic executive team. Before we get started, a few quick reminders. Please make sure your microphone is muted when you're not speaking. If you're here in person, please silence your cell phone like I am doing now to avoid any interruptions. And finally, please note that this meeting is being recorded. We're holding the meeting in hybrid format. Board members and staff are here in person, and we are also offering the ability to watch and participate in today's meeting virtually. Physically, the meeting is being held in the Cannabis Control Appeals Hearing Room in Sacramento. We thank the CCAP team for their hospitality. Today's meeting will follow the Bagley-Keene Open Meeting Act as required by law. The agenda and supporting materials are available here in Sacramento and on the CPPA website. You may notice board members accessing their laptops, phones, or other devices during the meeting. They are using the devices solely to access board meeting materials. This is a hybrid meeting, as I mentioned. Public comment is welcome in both in person and via Zoom. After each agenda item, there will be an opportunity for questions and discussion by board members. We will then invite public comment. Each speaker will be limited to 3 minutes per agenda item. Please note the legal rules for public comment. Under the Bagley-Keene Open Meeting Act, both board members and members of the public may only discuss items that are listed on the agenda. All comments must relate to the agenda item being discussed. There are 2 limited exceptions to this rule. First, item 7 today is our general public comment period. It's labeled public comment on items not on the agenda. When I call this item, members of the public can speak about topics that are not on today's agenda. Board members, however, cannot. Indeed, we may only listen and cannot respond. Second, item 8 today is our item for future agenda items. Under this item, both board members and the public can suggest topics for the board to consider for a future meeting. We cannot discuss these topics, only whether to put them on an agenda. If you're joining via Zoom and wish to speak on an item, please wait until I call for public comment and use the raise hand feature under reactions located at the bottom of your Zoom screen. If you're joining by phone, press star 9 on your phone to show the moderator that you are raising your hand. When it's your turn, the moderator will call your name and ask you to unmute. Zoom users can use the unmute button. Zoom interface users. Phone users can press star 6 to unmute. After your comment, you will be muted by the moderator. Please note that the board cannot see Zoom participants. If you'd like, you may identify yourself when speaking or use a pseudonym when logging in. This is completely optional. You do not need to identify yourself, but it can be helpful to us. If you're here in person and wish to comment on an item, please wait for public comment period to be announced and form a line at the podium to my right. When called, please speak clearly and directly into the microphone so remote participants can hear you and your remarks can be recorded in the meeting record. Again, it's helpful to identify yourself, but you are free to not state your name or use a pseudonym. If I happen to forget to call for public comment on an item, which regrettably has occasionally happened 2 times, please raise your hand and the moderator will make sure that you're recognized. Hybrid meetings can be technically complex, and so we greatly appreciate your patience. Thank you to Serena Carwile, our moderator, and Artem Andrasov for managing the technical side of today's meeting. Please bear with us if we experience any technical issues. If we do, we will pause the meeting to address them as needed. If you're attending remotely and you experience a technical issue like the audio dropping, please email us at info@cppa.ca.gov, India, November, Foxtrot, Oscar @cppa.ca.gov, and this inbox is monitored during the meeting. If there are any technical issues, again, we'll pause and resume, so please do let us know. We'll take breaks as we need, including a lunch break. I'll announce each one and let you know when we'll resume. Please also note that agenda item number 9 is a closed session item. I may call that during lunch, and I'll let the public know when we begin and when we return to open session. My thanks to the board members for their service and everyone helping to make today's meeting possible. Special thanks to our Executive Director, Tom Kemp, and our General Counsel, Philip Laird, who's our meeting counsel today, and to all of the expert CPPA staff who are presenting today. I would like to thank and welcome our moderator, Ms. Serena Carwile, and ask her to please conduct the roll call.
Board Member Liebert.
Here.
Board Member McTaggart.
Present.
Board Member Nonecki. Here. Board Member Worth.
Here.
Chair Urban.
Present.
Madam Chair, you have 5 present members and no absences.
Thank you very much, Ms. Carwile. The board has established a quorum, and I would like to remind the board that we will be taking a roll call vote on any action items today. We will now move to agenda item number 2, which is an executive director update. Our executive director, Mr. Tom Kemp, will provide some updates to us, and I'll ask Mr. Kemp to please go ahead when you're ready.
Thank you, Chair Urban, and good morning, board members. Recent headlines have demonstrated the importance of our mission here at the CPPA. From the headlines of the horrific Minnesota assassinations, where the killer was able to get politicians' home addresses via data broker sites, to the headlines regarding our residents' precise geolocation, airline ticket purchases, and even our medical bills being sold to third parties, to the headlines regarding recent large-scale data breaches that have made our Social Security numbers and medical information more accessible on the dark web, it is clear that now more than ever, the agency must remain resolute in its mission to help Californians protect their privacy. Californians want their personal information to be used only for the purposes they specify, and they expect businesses to collect their personal information only for clear, specific, and legitimate reasons, and to safeguard that information from security breaches. To meet the expectations of Californians, the CPPA is currently focused on 3 main initiatives. First, the CPPA is working hard to protect and expand privacy rights for all Californians. Let me give you 3 quick examples of this. Number 1, we are one of the first government entities to push back on the federal AI moratorium that would have stripped away many important protections that consumers in California and across the country enjoy under state laws. We are pleased that this proposal was voted down in the U.S. Senate. We have in our supporting proposed bills, number 2, we have in our supporting proposed bills here in California that, among other things, will increase transparency about data brokers' collection of our personal information and ban the sale of precise geolocation. Over the last 3 months, we've met with dozens of members of our Senate and Assembly and will continue to strengthen our collaboration with the legislature and the governor's office. Ms. Mahoney, our Deputy Director of Policy, will provide an update on our legislative policy agenda shortly. Number 3, actively engaged in enforcement and have numerous ongoing investigations affecting Californians. We are also collaborating with other privacy regulators in different states. Okay, yeah, it's hard to tell. Thank you. We are actively engaged in enforcement and have numerous ongoing investigations affecting Californians. We are also collaborating with other privacy regulators in different states and with the California Attorney General. Mr. Macau, our Deputy Director of Enforcement, will provide an update on our enforcement efforts at the next board meeting. Number 4, we are enhancing privacy and cybersecurity protections through our ADMT risk assessment and cybersecurity audit regulations. If approved, as presented to you later today by our General Counsel, Mr. Laird, California will set the gold standard in these areas, even after the recent changes we've made. And number 5, we are improving privacy literacy through our ad campaigns, social media efforts, and community outreach. For example, we are collaborating with other state agencies at an event with Senator Ashby on September 10th in her district that will focus on elder fraud and how seniors can avoid scams and better protect their personal information. Also, we will be significantly enhancing our privacy website to provide more details about the concrete steps Californians can take to protect their privacy. The second main initiative aims to help Californians exercise their privacy rights more easily and at scale. Too often, exercising privacy rights puts too much responsibility on individuals and becomes a never-ending series of chores. We are focused on operationalizing privacy for consumers by doing the following. Number one, we are sponsoring AB 566, the California Opt-Me Out Act, which will require all browser developers to offer an opt-out preference signal, or OOPS. This will allow consumers to opt out of the sale and sharing of their personal information at scale and do so with a simple setting in their browser. And number two, we continue to develop the delete request and opt-out platform, or DROP system, as called for by SB 362. When up and running in 2026, this will give Californians the only one-stop portal in the world where they can request hundreds of data brokers to delete their data. Now, to ensure DROP success, we are working on making the DROP system as easy to use and frictionless as possible for all Californians. We're also proposing modified regulations to make it easy for data brokers to operationalize their responsibilities under the Delete Act, which Mr. Laird will also cover this afternoon. And we're continuing our data broker registration enforcement sweeps to ensure all data brokers who need to register are in fact registered. In the future board meetings, we'll discuss our outreach plans to educate as many Californians as possible on the advantages of using the DROP system. And finally, the third major initiative is to strengthen the CPPA itself. Ms. Chittimbera, our Deputy Director of Administration, will update you on the success we've had in further expanding the team and obtaining approval for our budget request. As mentioned, we're building tighter relationships with other state agencies. And from an outbound public awareness perspective, we're also looking to consolidate our web presence, and we'll have more streamlined positioning of the agency to the public, which we'll discuss in future meetings. In summary, we as an agency are grounded in addressing real-world privacy harms for Californians. The agency is proud that we are proposing the nation's strongest regulations for cybersecurity audits, risk assessment, and automated decision-making, that we are on the forefront of proposing new privacy-enhancing legislation and building a first-of-its-kind DROP system that will break the cycle of consumers seeing the exercise of their privacy rights as being an endless set of chores. And we're forging strong relationships with industry, civil society groups, and our partners in California government. Thank you for your support, and I can answer any questions.
Thank you very much, Mr. Kemp. Questions or comments from the board? Yes, please, Mr. McTaggart.
Mr. Kemp, I know how involved you were in the Delete Act, and I got to tell you, it just is thrilling to hear someone in this room say the first and only one in the world. You know, that's a fabulous thing for California to lead the way in privacy, and I think the notion that you can do a one-stop shop and get rid of all your data from data brokers is extraordinary. So thank you, and good luck to your whole team getting that thing organized.
Thank you.
Thank you, Mr. McTaggart. Other comments? I have a couple. So to follow up on Mr. McTaggart, I just want to report that when I am at conferences with privacy and security lawyers or giving talks, I have heard I've had a lot of questions about the Delete Act and about the DROP system. People are very excited about it, and they also want to know if it's something that other states can use. And my understanding is we are building this so that other folks don't have to reinvent the wheel, which I think is amazing and wonderful. Is that correct? Also, I don't want to like commit you to the extent that it's possible.
In talking with other state legislators, we've heard strong interest. A recent presentation was done in which at least 20 different state legislators expressed strong interest in equivalent system. So I think it's critical for California to properly implement this system, getting it up and running, showing its value. But yes, once we get the system up and running, proving its worth, I think we will be very interested in partnering with other jurisdictions to ensure that the type of privacy capabilities extend throughout the United States.
Wonderful, thank you. Thank you, Mr. Kemp. It's a way that California can be of help to all of our partners in other states, and we often are by leading. So thank you so much to the staff and to you for the work on that. I also wanted to mention how immensely impressed I have been with the building out of the public awareness program that we heard about in May. I don't know if people have seen, I'm not sure both commercials are out yet, but both commercials are out. I've seen one in the wild, and we'll look for the other one. I really encourage people to watch them. It's a commercial. You may think, why is she asking me to watch a commercial? Because they're very educational without being dry, and I think they convey the message of the agency and what it is that the agency's mission is very well. And I really commend the team for that and for the very sort of thoughtful and considered effort. I know the team is also working really hard to connect with communities in California, as we've talked about many times, and I'm very impressed with their work and grateful for it. I also wanted to mention on enforcement. This is so nerdy, but I know we have a lot of lawyers in the audience. The board has been really eager to see how the enforcement team approaches the California Consumer Privacy Act in addition to the data brokers. I've been very impressed with the team's work there. And there's been a lot of uptake and discussion of the published settlements in the privacy legal community and the compliance community, which in my view is one of the great purposes of enforcement, is to provide guidance to people so that they understand how the agency is seeing the law as the law should be implemented. So my nerdy update is that it is July and law professors start getting emails with all of the information about updates to casebooks, which are the textbooks that students use in law school to study the law. They read real cases put into context so they can understand how to reason like a lawyer in that area of law. To the enforcement team, this is to you, the Honda settlement has been put into a casebook as an exemplar case. That makes me very proud and happy that it is seen as exemplar enough to be training our next generation of lawyers. So I want to congratulate the enforcement team on that. And I know we're going to hear about the administrative division and lots from legal division today, but I did want to say those things. Comments from other members of the board? Mr. Liebert.
Thank you, Chair. I just really want to echo what Board Member McTaggart has said about the DELETE Act and just how monumental it is. The idea has been that companies get to use our personal data unless we tell them not to. That is the fundamental Faustian bargain that we never entered into as Californians or as Americans. And because of leadership, in fact, the leadership of Board Member McTaggart, we now have this amazing statute that we're trying to implement. But we're crawling up, and it's hard because that fundamental evolution of the internet started in the wrong way. The idea that the data is theirs unless we say you can't use it. So I just think we need to remember as we go up to that 30,000-foot level that that's what we're engaged in. That we should have been in a situation where we first were asked the question, do you consent to using your personal information to be sold or shared across the internet and across the world? And so our challenges are immense. And I think that the promise of the DELETE Act is extraordinary. And obviously we're all very, very hopeful that it will be successful. And the first steps that you've described, Mr. Kemp, are very encouraging. We got to do this right, and I think we're on the path to doing so. So thank you all who are working so hard to make that work and have California once again do what it always does, and that is be the leader, not just in this country, but of course in the world on these issues.
Thank you, Mr. Liebert. Is there public comments on this item?
This is for agenda item number 2, the executive director's updates. If you'd like to make a comment at this time, please raise your hand using the raised hand feature or by pressing *9 if you're joining us by phone. This is for agenda item number 2. Madam Chair, I'm not seeing any hands raised at this time.
Okay, thank you very much. Thank you, Mr. Kemp. I feel remiss that I didn't identify the casebook, again, for the lawyers. So it's Matthew B. Kugler, who's a professor at Northwestern School of Law, his Privacy Law Cases and Materials, second edition. So anyway, thank you, Mr. Kemp, and thanks to board members for their comments. With that, we will move to agenda item number 3, which is our annual administrative update, and will include budget and hiring metrics. This will be presented by our Deputy Director of Administration, Von Chitambira, and I'd like to ask everyone to please turn your attention to the materials provided for this agenda item. And Ms. Chitambira, I believe, will present the slides and request our questions and comments as she goes. So Ms. Chitambira, please go ahead.
Good morning, Board Chair and members of the board. Can you hear me okay? A little closer. Not too close, just right. I'm pleased to present the administrative and budget update for the agency. Please note, the slide deck being projected reflects the most current information. There have been some updates to slide number 6 and 14. So I encourage you to follow along with the slides that are being presented on the screen. I will begin with an overview of our prior operations, highlighting a few accomplishments and updates across the 3 main administrative units, being business operations, human resources, and fiscal services. Next slide, please. And starting with business operations, next slide. Our Sacramento office continues to operate out of the temporary space at 400R, which was selected after extensive review and identified to be the best location to maintain proximity to the Capitol as well as other state departments. Our business operations team has been working closely with DGS Real Estate Services Division on our permanent location. Bids for the necessary tenant improvements have been received and evaluated. The offer for the tenant improvements is now under review. Once that is awarded, the contract can be signed and for the permanent lease. We're expecting the lease to be signed mid-August 2025, and based on current estimates, which include permits, material lead times, fire marshal inspection, we anticipate moving into the permanent space in August 2026. We continue to leverage our DFPI contract for the LA and San Francisco locations. Moving on to business processes. As the agency has continued to grow, we have also worked on formalizing our business processes and procedures. We've made a concerted effort to document and formalize business processes to ensure consistency across all divisions. We've also worked closely with the HR team with updating our onboarding procedures, working also with Public Affairs Division to enhance employee communications. When new employees are hired, we are sending out an onboarding survey to get input from them, as well as when employees leave, our HR team conducts exit interviews. This way, we're able to gather valuable feedback to help us continue to improve. We believe this, in addition to other improvements we've made across the division, has helped us foster an environment where our employees can succeed, as well as maintain a high retention rate with our permanent employees. Moving on to data broker registration. 2024 marked the first time processing for data broker registration payments was done in-house. Our accounting team developed a structured payment processing framework to ensure timely and accurate transactions with lean resources. Due to the short time frame the agency had to develop the payment process, all domestic registrations were physical checks. As of December 1, 2024, we had successfully implemented this system, and at the end of the registration period, we'd processed payments for more than 540 data brokers in 2024. In 2025, we enhanced our payment processing capabilities to include credit card payments, as well as wire transfers. This required several process improvements, including securing a vendor for online payment processing and establishing a new bank account to manage those payments. Those changes further enhanced efficiency for payment processing. I will move on to contract recognition award. State departments are required to set an annual goal of 25% of total contract dollars to be performed or supplied by small businesses. In March this year, our agency received an award for surpassing this benchmark, achieving more than 90% for 23-24 fiscal year of our payments of our contracts being awarded to small businesses. This success reflects an outstanding work from our procurement team and the valuable effort with our partners from DGS. Next slide. As our department continues to grow, we also have to maintain many compliance requirements. In the past year, we onboarded 23 employees, including consultants, interns, and temporary staff that we brought on board, reflecting our agency's footprint has expanded in only the past 4 years. With this growth, we are reaching a point where routine audits and oversight reviews are expected. We're currently undergoing our first audit with the State Personnel Board, which is evaluating our hiring practices to ensure that we meet state requirements. We anticipate hearing back from them in the next few weeks. I just wanted to note that this is a normal part of a maturing organization, that as we continue to grow, we can expect to get more audits from oversight agencies, and this is nothing out of the ordinary. We recently established a Disability Advisory Committee. This is also another requirement for state departments. It is comprised of employees committed to representing disability issues. The committee provides leadership with valuable insights on improving resources and support. We successfully drafted our bylaws for the Disability Advisory Committee, ensuring a strong foundation for its work. Even before the DAC committee was created, the agency ensured broad outreach to attract the most qualified candidates and fostered an inclusive workplace where everyone can excel. In June this year, CPPA was awarded the 2024 Association of California State Employees with Disabilities Employee of the Year Award among small departments. We were recognized for our commitment to ensuring accessibility and an inclusive workforce. I want to acknowledge our HR team, as well as all the employees who currently sit on the DAC committee for their work. Now moving on into the hiring update and diversity metrics. We currently have 53 authorized positions. 43 of these are permanent employees. 4 are employees in temporary positions. So temporary refers to positions that were administratively established or retired annuitants. And we currently have 1 intern. In the past, the board has requested to receive workforce data for the agency. Following through with that request, the next few slides will provide an overview of our current workforce composition. The data was collected from the CalHR website. For context, as we compare our statistics with those of the other state departments, we're comparing about 50 employees to more than 200 state employees. So starting with gender, CPPA overall has 29% male representation and 71% female representation. And on the right, you see the comparison for the state. Overall, male representation is higher in state service as compared to our agency at the moment. In management, our female representation is also higher than overall state departments. And this aligns with the number of employees we have that are female. And the next slide shows ethnicity. We have a comparison of ethnicity of all state employees compared to CPPA. The ethnic composition of the agency closely mirrors that of the state with only slight differences. The exception is Hispanic representation, where CPPA is lower. While we don't target specific ethnicities in our outreach, we're committed to advertising our positions broadly to reach wide and diverse pool of candidates. Employees with disabilities. CalHR sets a 13% representation goal for employees with disabilities. I'm proud to share that our agency currently stands at 26% compared to 8% statewide. Again, this reflects our commitment to a diverse and inclusive workforce. Some of the contributing factors to our higher representation is that we amplify our positions with Department of Rehabilitation, and our Public Affairs Office also does a great job in amplifying our positions once they are posted online. We also distribute an annual survey to our employees who have had changes in their disability status. When employees are hired, sometimes they don't always disclose, but once we send out the survey, more information is then shared directly with CalHR, from which we get the information. And now we move on to the budget planning update. So I'll begin with a summary of expenditures for fiscal year 25-26. Total expenditures for fiscal year 25-26 were $14,190,000, and these were funded by the General Fund and the Data Broker Fund. Going into the General Fund, we had 49 authorized positions that were funded by the General Fund. $7 million was for salaries. Facilities and department services were $896,000. Operating and equipment were $3,838,000, coming up to $11.8 million. The facilities and departmental services includes the facilities lease, as well as our interagency agreement with our partners at DGS, CDT, and DCA. As of today, our accounting books have not been completely closed for the fiscal year that just ended. As we continue to record expenses that occurred at the end of the fiscal year, we can expect to see slight changes in the total amount of expenditures. But that summarizes our general fund expenditures for fiscal year 24-25. And moving on to the Data Broker Fund. Salaries and benefits were about 16% of the total fund. And the largest expenditure was operating expenses and equipment, and that made up 74% of the budget. Most of it was allocated to CDT drop projects. And our current year budget for 25-26. Our budget this year was approved, and it includes 3 BCPs, budget change proposals. The budget also includes trailer bill language, which I'll go over shortly. The first BCP was for the Data Broker Delete Request Out platform. The proposal requested for 2 positions and $4.8 million over 2 years. Enforcement resources, the agency was approved $700,000 from the Consumer Privacy Fund over 2 years for the enforcement division to build out the enforcement infrastructure, including data analysis tools, expert technology services. This investment helps equip us to strengthen enforcement efforts and advance our mission. The next BCP was for facilities relocation. We received $421,000 to cover facilities expenses for the Sacramento office, and that's for the permanent space. The trailer bill language, in addition to the BCP, the agency worked with the Department of Justice on the trailer bill language, clarifying the administration of the Consumer Privacy Fund. The language simplified distinguishing between contributions from the agency to those from DOJ. It will also improve transparency in tracking deposits available for grant funding. The trailer bill resolves questions about how CPPA and DOJ will coordinate accessing the Consumer Privacy Fund. Each entity will be able to access fines or penalties from its own CCPA enforcement actions, which will be housed in separate sub-funds of the Consumer Privacy Fund. If an action or settlement is a result of a joint investigation with our agency, DOJ may deposit a portion of those funds into the CPPA sub-fund for reimbursement of investigative costs. The trailer bill also sets up a system where 5% of the fines and penalties in each entity's sub-fund automatically go to the grant fund sub-fund. CPPA is required to administer the grant program when the funds in the grant sub-fund exceed $300,000. The total budget for the current fiscal year 25-26 is $15,770,000, and this is spread over 3 funds. Beginning with the general fund continues to maintain 49 positions, and we're currently budgeting to spend $10 million in salaries and benefits. And this assumes that all our permanent positions will be filled. Facilities and departmental services is budgeted at $1.5 million, and operating expenses and equipment is budgeted at $767,000. Moving on to the Data Broker Registry Fund. We budgeted $719,000 for salaries, with the remaining $2.3 million allocated to operating expenses and equipment. These costs cover covering project management, infrastructure, ID verification, and other related costs. Separately, I wanted to note that we received registration fees in 2025 for the Data Broker Registry, and the amount we received came up to $3.6 million. This includes registration fees as well as the fines and penalties. Registration alone was about $3.4 million, nearly $3.5, and then fines and penalties almost just a little bit over $170,000. And in addition to the Data Broker Fund, we have the Consumer Privacy Fund, which is currently funded at $400,000 for this current fiscal year. And that is all for enforcement activities. Going on to the budget considerations. As we look into the next fiscal year, 25-26, one of our main priorities will be evaluating our administrative infrastructure. Working closely with our partners at DGS, we've seen that as our agency continues to grow, there's increased pressure to bring more resources in-house. We've exceeded the size of departments that DGS typically supports, and we're currently identifying which administrative programs make sense to bring in first. And that may involve requesting funding to support the resources internally. Part of the funding will take into account the cost of living adjustment, which we'll calculate after August when the CPI is published. We plan to have an adjustment to supplement resources needed for administrative functions as we transition in-house. At this point, the 3 main areas we're focusing on are HR, contracts, as well as fiscal services. We expect to start with one that is least difficult to transition in-house, and that assessment is still ongoing. We're also looking at long-term expenditure plan and ensuring that we have appropriate level of resources to support the needs of our programs, specifically with increased enforcement actions and settlement revenues from the Consumer Privacy Fund and the Data Broker Registry. We will evaluate ongoing enforcement staffing levels. We'll continue to evaluate our costs over time since we now have historical data to better understand our resource needs and to support the mission and anticipate future costs. And that concludes our budget update and administrative update. I welcome any questions.
Thank you, Deputy Director Chidambira. Questions and comments from the board? Mr. Worth?
Mine's related to towards the end of it, the budget. If anyone has something before that, they can go ahead of me.
Did I get this right, that for drop, we're ultimately having 4 authorized positions, but right now we've got 2 people focused on it.
We currently have 2 dedicated resources, yes, and we are expecting to hire 2 more, and those recruitments are underway.
So the remarkable thing, just one of the many remarkable things about ChatGPT and AI is I asked AI how many employees Meta has. 86,000. I asked about Google, they said 190,000. I asked how many lawyers does Meta have? And I'm not picking on these technology companies at all, except to show that we've got potential misalignment here. So here we have what we're just informed may be world-leading approach on data control by people in the drop system. And we're talking about 2 to 4 people being dedicated to that project when it's just so misaligned, right? And so I think we recognize that we have a highly efficient team, but wow, that's not enough people. And I know you're doing the best that you can, but we've got some very serious budget constraints going here that are going to limit our capacities in ways that I think are unfortunate, and I hope that somehow we can deal with that over time because the work is immense, right? And I applaud the work that you've done already, but we're just not able under these resources to be adequately beefed up, obviously, to deal with. I can imagine appropriately that if Meta, for example, were to do a drop system, would have thousands of employees, at least hundreds of employees figuring out how to do it and to do it well, and they would do it well. So many times government is so criticized for not being able to be as nimble as it should be. But this is certainly an example, in my judgment, of really being highly under-resourced for what's really a potentially critically important project to protect consumer privacy, not just in California, but across the country.
Thank you, Mr. Liebert. That prompts a question for me, which is, what do you see, Ms. Chidambira, as the sort of biggest needs right now? So I heard continuing to build out our administrative infrastructure, bringing things in-house. You should try searching, Mr. Liebert, how many administrative professionals of various types these companies have, because they're crucial to the mission of any organization and sometimes get forgotten. So I heard that, I thought, but I would like to hear more. You said something about enforcement that sounded very gentle. But it also sounded like, and this again is to sort of following on Mr. Liebert's point, that might need to be a priority as well. And so I could also be filling in a little bit. So I would really be interested to hear, to the extent that this is an appropriate time to talk about it, how you see some of the priorities over the next couple of years, which I think will help us understand or help us analyze what we think our priorities are.
Absolutely. We've had some preliminary discussions with the different deputy directors on the team about resources that are needed going forward. One that does stand out for sure has been the enforcement division, and they give a comparison with other jurisdictions of the resources they have compared to what has been approved in our budget. There's a lot less from the perspective of what needs to be done in terms of enforcement. So that's one for sure. Administrative division, when the agency was created, the intent was always to have administrative in-house for the functions, but at the time it made sense to leverage existing resources with DGS. And we've continued to leverage DGS resources because of the climate that we've been in, but ideally we would want to have all the functions in-house, so that includes HR, procurement, as well as our budgeting and accounting services. There's more urgency on the procurement side because, as you know, with our agency, we have a lot of contracts that we have to go out to procure, and we don't always have enough time. We work with very short lead times within our agency. We're a very lean team, and working with DGS, they are not always able to meet our timelines the way that we need them. And so there's that need for us to have procurement in-house. And that will result in us having to submit a BCP and justifying what each and every one of those positions will be doing. That's on the procurement side. As well as facilities. We've been very fortunate to be able to use DFPI resources, and we're lucky that the return to office was rescinded, but had employees been required to go back to the office 4 days a week, there would have been less capacity for DFPI to provide space for our employees. So we'll need to focus on expanding facilities in LA and San Francisco, just like we're doing in the Sacramento office. And then in our discussions, also working on the BCP for the next cycle, our legal team is going to need additional resources. I know we've currently administratively established an attorney position to help with some of the workload, but it'll be necessary to make that position permanent, because if it's administratively established, there's no funding associated with it. We're using existing funding, and that means using our cost savings from the vacant positions. But once we fill those positions, we'll need additional funding. So legal, enforcement, and administration need additional resources.
Thank you very much. That's very helpful. I'm sorry. Are you okay, Dr. Nonagi?
Thank you so much for your presentation. I have a question on the drop system. As I understand it, the California Department of Technology is helping to build this out. Is there budget for continuous monitoring and assessment via CDT for drop?
So ongoing monitoring, there's work to be done in that front. I know our chief deputy is more involved on the drop project, so she can provide some more insight on what the plans are beyond the current budget cycle.
Good morning. At this time, we have a multi-year contract with CDT, but it's for 3 years, and so we'll evaluate that at the end of it. And then in terms of specific resources, we only have resources for the next 2 years related to drop, so we do plan to submit a future budget change proposal for ongoing resources, but part of it, those costs and workload are in flux, so we still need to evaluate it once the system's up and running.
Thank you. Mr. Worth.
Yeah, looking at this year's budget, the 4.8 million over 2 years for drop, what is that covering?
Just one moment. I do have a few notes on that. So there are quite a few areas that are included. It's mostly the implementation of the system. So that includes the infrastructure, the development and post-implementation, and that is, the development is the biggest portion of the budget this year, which is 1.1 million. We have residency verification, overhead, and then CDT project management, support for the ticketing system, as well as general operating and expenditures, so OE&E, other expenses that come up to support operations. But it's primarily related to drop.
May I ask quickly on the residency verification, is that expenditure to build it or to build it and then continue to maintain it,
I'm sorry.
or the function itself?
On that one.
CDT has built out a platform called the Digital Identity Gateway, and there's a specialized team that has built that, and they partner with other agencies throughout the state, as well as regional transportation. Furthermore, one of the key identity providers of the digital identity platform is login.gov. And so we are actually leveraging, as the identity verification platform, the California Digital ID Gateway. And in the initial release, the verification will happen via either login.gov or through a contract with a company that CDT procured called Secure, which will provide the IAA level 2, which basically you have to show identification or have additional proof to do the residency verification. And we've updated the regulations. One of the updates clearly states that we will provide identity verification for all consumers leveraging the platform.
And so the $1 million and some will be used for what?
So the estimated cost, and I think the current year is for the contracts to pay SoCure and login.gov, depending on consumer utilization of the identity verification.
Okay, so that's an ongoing cost? We will
Yes.
always need to pay that. Okay, thank you.
It's okay. I was kind of going there. So 4.8 million over 2 years. Year 4, what's the cost going to be associated with drop? And if you don't have it now, we can talk about it later, but I'm just trying to build a long-term budget in my head right now.
I would say at this point, we don't have a long-term budget, and we're
You
still.
have 2 mics now.
This one's off. And we're still trying to assess the ongoing need. And again, as always, the fees will be, for data broker registration, will be calibrated to only recover the costs associated with the system.
Right. So, well, I'm gonna go there next. Just real quick on the lease cost, the 420,000, that's a one-time, or that's ongoing?
That is ongoing.
So our rent is basically $400,000 per year more than it currently is. I think it was working, huh?
It is working.
Yeah,
Yes.
you're good.
So our rent for the Sacramento office is a little bit over 200,000. But in addition to the rent, there's additional funding that is needed for maintaining facilities. So that is included in the budget.
Got it.
Within the
Okay. So that's every year, that increase.
Yeah. There'll be a 4% increase annually to the rent.
Got it. Yeah, one of the benefits we've had with the inflation is our cost of living's been pretty good, but my guess is it may not be that high going forward. So our annual growth in that general fund dollars is going to go down. So where I'm trying to get to is we have these additional funds that come from 2 sources, right? You got the base 49 positions and then the 53 we're trying to cover. The data broker, what are the rules about how we can spend the data broker registry funds and any of the enforcement funds? Are there any rules around, any restrictions, I should say, around how that money can be used?
Good morning, members of the board. So starting with the Data Broker Fund, as you know, that's a special fund funded by data broker registrations as well as then enforcement penalties. That essentially is by statute required to be spent on implementing and maintaining both the drop system and the registry, and essentially implementing that Delete Act. So it's fairly flexible as long as it's focused on the functions carried out and directed under the Delete Act. Separately, in terms of the Consumer Privacy Fund, that one is also can be used for purposes of essentially implementing the CCPA. So it's pretty broad in terms of what the agency can use it for.
And the registry funds should be consistent every year? I mean, or is that how often is that, do I have to register every year and pay that same amount?
You have to register every year, but that's to Ms. Garcia's point. We fully intend every year, in fact, we intend probably in the next meeting to bring to you proposal for a potential updated registration fee, again, to reflect our actual costs that we anticipate and have expended.
My guess is not going to go down. Maybe. We'll wait till the next meeting. Now let's go to the enforcement funds. That's the one.
Yes.
What are the registration fees you just told me about? How about enforcement?
Oh, no, so enforcement actually can be used to implement for anything to implement the CCPA that this agency is responsible for.
Okay. Yeah, my only concern, I'm just because I don't have my head around this yet, is if we start budgeting dollars that aren't consistent, we're gonna have a really tough time if we have a down year in enforcement fees. So how do we protect against that? We're drawing dollars from sources that aren't necessarily consistent into a budget that is growing.
So in terms of data broker, at least we have the annual registration.
Right, on the registration, that's fine. Yeah.
On the Consumer Privacy Fund, because the volatile nature of the revenue stream for that, to date, we've only requested one-time funding, knowing because we can't budget ongoing. So that's the request for 700,000 over 2 years. And we can't.
That's one project that goes away. Okay. Got it. Okay, that's it. Thank you.
Thank you, Mr. Worth. Mr. McTaggart?
Thanks for this great presentation. Okay, so just a couple questions, and I'm sorry I don't understand fully, but the budget change proposal, a couple of things. So is that 700,000 for enforcement, is that incremental above what we already are spending, or is that the total amount we're spending on enforcement?
Oh, It's in addition to what we were spending. So they do have general funding already that is covering their salaries and OE&E, and then this is in addition for additional tools.
Do you happen to know kind of roughly what percentage of our total expenditure is spent on enforcement, like, ish? Are we sort of spending 30, 40? I mean, I just, it's such a priority, I think. It'd be interested to know, and you can maybe just get back to us, get back to me. That would be interesting. And then I was a little confused, you're saying that DROP has 3 people on, like, they're not on page, but 24 or 25, and then 25, 26, it says 2. Is that, so it's going to be 5 total? Is that what we're trying to say? Because it goes from 3 to 2.
I thought we had 4 positions dedicated. It may be 5. It is 5
it's 5.
positions.
Okay. All right.
Sorry, what is reflected in the chart is authorized position and how the state budgets, and because they start mid-year,
Right.
they're technically half a position. That's why Vaughn's 4 is accurate in terms of authorized, but it's actually 5 bodies.
5 total,
So
okay.
sorry.
And then when I think of, where was this page here? So on whatever this page is, 25, 26 overview, says general fund, salaries, that I get to total budget of 12,290. And I recall, I just went and looked, I recalled in the 24 annual budget or annual report, it was talking about 12.8 as our annual fund. So I'm just kind of wondering, does the 12.8 refer to something else different? It's that nice report we produced at the end of the year. And I'm pretty sure we didn't go backwards. So I'm just kind of wondering, and I don't, again, I don't want to hijack this, but I just looked at the 12.2 and I ran the numbers for the CPI and it kind of works, but I do recall we were higher. And then in the annual report from last year, it shows that our funding was 12.8 million. For the 24, if I'm looking at it here. Yeah, and I'm not, it just says the agency's financial resources have grown to 12.8 million for the 24-25 fiscal year.
That's
But maybe something
starting
different.
now and going through next June. And the annual report talked about starting in July 1st of 2024 and going through June 30 of this year, or possibly even the year before that.
Right.
So we
So
had a
with-
run up in inflation.
I know, but
Yeah.
that was more last year than going forward.
Right, because it goes up or down, right? Depending on the CPI.
We didn't go down, though. Sure didn't go down.
It didn't go down? Okay.
So
It was
anyway,
really high last year, I know.
so anyway, again, if you could just get back to me on that, it's not, it may just be I'm sure it's just like a different bucket thing and we didn't, one's talking about one set of buckets and one's talking about the other. Including drop. Yeah. Yeah, just if you wouldn't mind, just on the, because it says it on, whatever, it says it twice in that 24 report of 12.8 million. I'm sure it's just one included one bucket, one included another. And then my last question is, when we're talking about the data broker thing, we keep on talking about the implementation and I'm just going to repeat what everybody else has said. So I'm looking at that 1.9 million number. Are we just talking about programmers to make it happen? What's the 1.9 million? Some of it's fees to pay for the state identity verification, but that sounds like it's a couple $100,000. So I'm just trying to wonder, how do we get to just big picture, how do we get to the 1.9 million-ish again?
Which slide are you on?
1.9 million is the data broker fund, 3 authorized positions, salaries and benefits of 396. And it's on page 24, 25, and operating expenses and equipment, 1.9 million.
So there's the identity verification piece. There's just standard OE&E for staffing. There is both project management resources from CDT as well as their overhead costs, and then the contractors that we have to assist them with the build. But we could also provide a more detailed breakout.
And Ms. Garcia, if I may, I was going to also add on the identity verification piece, I just want to point out that's not necessarily a flat rate. That's contingent on the number of consumers accessing the system. And so you can imagine that could be a real fluctuation depending on user uptake.
Great. If you're providing the other information, if you could just break down the 1.9 for us as well, that would be great.
Yes, happy to.
Thank you.
And then just to go back to your enforcement question, enforcement makes up 19% of our total budget. Thank you, staff.
Okay, thank you.
Thank you, Mr. McTaggart. Other questions, comments from the board? In that case, I will ask if there's public comment.
This is for agenda item number 3, annual administrative update, including budget. If you want to make a comment at this time, please raise your hand using the raised hand feature or by pressing *9 if you're joining on the phone. This is for agenda item number 3. Madam Chair, I'm not seeing any hands raised at this time.
Thank you. Thank you. Sorry. Now I feel anxious, and I don't know if my voice is being captured unless I hear it annoyingly popping. So is all okay? Okay, thank you. Sorry about that. The other microphones are a little, I think they're a little difficult to use, and I really appreciate the team's efforts. So with that, I'm going to suggest that we move on. We can do two things. We can move on to the legislative update and CPPA positions, or we could take a quick break. What would people prefer? Keep going? Everybody's ready? Okay, wonderful. Then we will move to item number 4, which is a legislative update and some information and recommendations on positions we might take on pending legislation. Please turn your attention to the materials provided for this agenda item. Our Deputy Director for Policy and Legislation, Ms. Maureen Mahoney, will present this item. Bear with us as we transition, and I'll just turn it over to Ms. Mahoney whenever she's ready.
Okay, start.
Please go ahead when you're ready.
Okay, thank you, Chairperson Urban, board members. Appreciate the opportunity to give a legislative update. Next slide, please. This item, I'll do several things. First, I'll provide an update on our engagement at the federal level. Second, I'll provide a brief multi-state update with a high-level overview of some amendments to privacy laws that have passed in the country so far this year. And then I'll turn to California. I'll give a brief update on the CPPA-sponsored bill, AB 566, on opt-out preference signals. Then I'll provide an update on the bills that the CPPA has been supporting or watching. And at the end, I'll present for board consideration recommended positions on 2 new California bills that have come forward since we last spoke that specifically amend the CPA or direct the agency to act. And after each of these sections, I'll pause for comments or feedback from the board. So first, I'll turn to our engagement at the federal level. As you may know, over the past several months, Congress has been working on a budget reconciliation bill, and the House version of that bill included a 10-year moratorium on state enforcement of laws or regulations that regulate artificial intelligence systems or automated decision-making technology. The bill passed the House with this provision. It was stripped out in the Senate. As Mr. Kemp mentioned, the agency actively worked to oppose the moratorium. We submitted an opposition letter in the House. We worked with some of our partners in the consortium of privacy regulators to submit a letter in the Senate and had ongoing conversations with members of the House and Senate. While the AI moratorium was successfully removed from the reconciliation bill, similar concepts are still in play. For example, President Trump released an AI action plan yesterday that includes the policy recommendation that, quote, I'm just going to read it, led by the OMB, work with federal agencies that have AI-related discretionary funding programs to ensure, consistent with applicable law, that they consider a state's AI regulatory climate when making funding decisions and limit funding if the state's AI regulatory regimes may hinder the effectiveness of that funding or award, end quote. The president also signed 3 executive orders having to do with AI, although none of them touched on state regulation. And some form of AI regulation, moratorium or preemption could go into another bill, for example, a potential second reconciliation bill in the fall, or as part of a light touch AI regulation proposal. So we'll continue to monitor and activate as needed. And Congress is still interested in privacy as well. For example, next week, the US Senate Judiciary Committee is holding a hearing on safeguarding Americans' online data. And as mentioned in May, the House Energy and Commerce Committee has a working group to develop a new privacy bill, so we may see activity in the fall.
May I ask a quick question, Ms. Maroney? Is it okay if we ask now? Or
Yeah, that's the end of my federal update, so this is a good time to
It's
stop.
on the federal update. Thank you, Ms. Mahoney, for indulging me. The plan that came out, the plan that the president announced was yesterday, and I had limited time to review it. I did look through it. I did not see any criteria for deciding if a state's regulatory climate hinders AI innovation. Did I miss something? Are there any criteria? Is there a standard? Is there any structure?
No, our understanding is that no specific criteria or structure was laid out.
Thank you.
As you can see, I have poured over the
She
AI.
has highlights.
I have highlights, I
Oh my
have
goodness.
notes, I have highlighted
Yep.
notes in the margins. No, essentially it would be to the federal agencies themselves to determine whether or not a state's law is overly burdensome. And that would affect the allocation of funding,
Right.
but no standard, no.
Mm-hmm.
Very
Okay.
discretionary.
Very discretionary. Yes. Please go ahead.
I'd like to just bring up one other thing at the federal level. Senators Hawley and Blumenthal introduced a bill around giving individuals rights over the use of their personally identifiable information in the training of generative AI models. Seems very close to home to the work that we're doing here. I do want to point out that there is a provision in the bill that states that state-level laws can, continue to be implemented even if they are stronger than the federal standard. So I want to flag that as that is quite amenable to what we've been trying to do.
Thank you, Dr. Nanaki. Yes, a non-preemption provision in that bill.
No bipartisan bill, yeah.
Yes, Senators Hawley and Blumenthal. Yeah.
Great, so moving to the multi-state update, just providing some high-level trends on what we're seeing in states across the country as the legislature here. So that have comprehensive privacy laws have working?
Not to take an agenda item out of turn, but maybe we should allocate some budget to buying some more of these mics for you all.
Testing, testing. Yeah.
Okay, how's this? A little bit better. Okay. So to the trending updates on privacy laws across the country, Colorado, Connecticut, Montana, and Oregon have passed amendments to strengthen their privacy laws. So a couple of the common themes that we're seeing, lowering the threshold. Montana and Connecticut have lowered the threshold of the application of their privacy laws. Also, several of the states have passed amendments to increase protections for minors. For example, Connecticut, Oregon, and Montana have prohibited targeted advertising, profiling, and sales of minors' personal information. Also, increased protections with respect to location data is a trend. Oregon has prohibited the sale of location data. Colorado has prohibited its sale without consent. Amendments have also modified consumers' access rights. Connecticut, for example, now requires disclosure of specific third parties to whom personal information has been sold. And then finally, as in California, states have continued to expand their definitions of sensitive personal information. For example, Connecticut's definition now includes disability status and status as non-binary or transgender. Next slide, please. So next, turning to California, first I'll provide an update on our CPPA-sponsored bill. Then we'll give an update on some of the bills we talked about at the last meeting that we're supporting or watching. And then finally, I'll present for board consideration recommended positions on 2 California bills. Next slide, please. And next, before I do that, I'll give my usual update on the timeline. We are getting pretty close to the end of this legislative session. We've recently passed the deadline for bills to make it out of policy committees in the second house. The legislature is currently on recess until August 18th. And then when they come back, bills have to make it out of appropriations by August 29th. They have to clear the legislature by September 12th, and then the governor has until October 12th to make a determination on the bills. Next slide, please. So next, an update on our CPPA-sponsored bill, AB 566, now called the California Opt-Me Out Act. This is a priority for staff because by requiring browsers to offer opt-out preference signals, it'll be much easier for consumers to tell businesses in a single step, I want you to stop selling my data. So the bill passed the Assembly in early June, made it over to the Senate. It has passed both committees in the Senate, both the Policy and the Fiscal Committee. So now it's eligible for a vote on the Senate floor once the legislature comes back. The author has committed to amendments to narrow the scope of the bill to browsers only. And those are expected to be taken on the Senate floor. And then we've expanded our coalition of supporters to include additional groups focused on child safety online, such as Mothers Against Media Addiction, and we're continuing outreach to reproductive privacy in labor groups. Okay, so now to an update on some of the bills we talked about at our last meeting. This is a list of bills that failed to advance this year. Some of them may come back next year. So 2 of the bills that we were supporting were stopped in appropriations, AB 1355, having to do with location privacy. However, I'll talk about this more in the next section because they found another vehicle for this bill. And then another bill we were supporting, SB 44, having to do with neural data, was also held in appropriations. A bill we had a support if amended position on, SB 468, having to do with high-risk AI systems and a duty to protect personal information, was also held in appropriations. Several of the bills we were just watching also failed to advance. So for the sake of time, I won't go through all of them and we'll just refer to the slide. Next slide, please. Okay, so now a quick update on some of the bills that we're supporting or watching that are still active. First of all, SB 361 from Senator Becker that amends the DELETE Act. It's intended to strengthen it by increasing the disclosure requirements on data brokers, stating that they have to provide more information to us when they register, for example, whether they collect government identifiers, union membership, location data, and things like that. So that bill, we're supporting that bill. It's still moving along. It has been amended to add additional reporting requirements, like whether a data broker has sold information to a foreign actor or to the federal or state governments or to AI developers. And then SB 470 from Senator Laird, we also have a support position on that. That has to do with how we hold our meetings. It extends the existing teleconferencing requirements under the Bagley-Keene Act, which are supposed to sunset this year. This would extend them for 10 years. So there haven't been any changes to that, and that's still moving along. So now to the bills that we're watching. AB 1018 is the first one from Assemblymember Bauer-Cahan that regulates automated decision systems for consequential decisions. We talked about that one at the last meeting. It has a broader scope, governs a greater scope of decisions, so our proposed regulations would fit inside it. It has recently been amended to remove the opt-out right and allow an automated pre-use notice, among other amendments. But this bill still affirmatively requires businesses to comply with our regulations where applicable, so we're looking at parallel compliance systems. Next is AB 1064. This is a bill that established a regulatory system for AI products targeted to children. That one has been narrowed down a bit. It's now focused on restricting certain high-risk AI products to minors in California, such as certain companion chatbots. And then we're continuing to monitor SB 7 from Senator McNerney that regulates the use of automated decision systems in employment specifically. So many of the obligations and rights established by the bill are similar to those in our proposed regulations. So like AB 1018, we're looking at parallel obligations for some businesses. However, we have been monitoring recently amended language that states that employers don't need to comply with substantially similar notice and appeal requirements in other state laws. So we flagged that provision for the author. And then finally, AB 1043 from Assemblymember Wicks. That's a bill we've recently been watching more closely. That bill requires mobile device and mobile app store manufacturers to send signals to app developers displaying the age range of the minor user. And we've been working with the author's office to ensure that final language clarifies that the signal is not automatically interpreted as granting parental consent for the sale and sharing of a minor's PI under the CCPA. Okay, yeah.
It's okay. Thank you very much for that presentation, very helpful. On AB 1018, the chair of the Privacy Committee, we have an interesting situation, right, where our proposed regulations, of course, have opt-out rights, and that bill removed that issue. But you made a comment which I found heartening, and that is that the analysis is that they're consistent. We're not in conflict. So I wanted to ask our general counsel that to make sure that because we are listening very carefully and watching very carefully about what our friends in the legislature are doing. So we want to make sure we're consistent with those efforts.
I've been tracking this along with Ms. Mahoney very closely, and yes, we feel very confident that these are compatible frameworks that don't create a conflict.
One point of quick clarification, which is that the opt-out right is in the statute that we must implement.
Okay, so for the final portion of this presentation, I'll walk you through two bills that directly affect the agency. One of them amends the DELETE Act, is the first one I'll go through. The other one amends the CCPA. So again, we recommend that the board consider taking a formal position on these bills. And for the sake of time, I'll just go through both of them and then turn it back to the chair for discussion. Next slide, please. So first I'll discuss AB 302 from Assemblymember Bauer-Cahan. This is a new bill. It was a gut and amend about a month ago. And it now seeks to offer additional privacy protections for government officials. So again, this amends the DELETE Act. It adds a new section to it. It has four main provisions. It requires our agency to obtain and maintain a list of state and local elected officials and submit deletion requests pursuant to drop on their behalf by March 1st, 2026, and thereafter following any election. Second, it also requires our agency to receive a list of judges from the Judicial Council and then also facilitate deletion pursuant to DROP. The bill requires the DROP notify data brokers of these requests and requires data brokers to respond to them within 5 days. It also requires that all information sharing pursuant to this be through a secure and confidential exchange. Next slide, please. So staff agrees that the bill is, the goals are extremely important, providing additional protections for elected officials, especially in light of increased violence directed towards them. It's very, very important. However, as drafted, staff does have concerns. First, in our view, we're not the appropriate entity to generate and maintain a list of state and local officials, just because there are other entities that are already collecting that information. Second, the bill doesn't require any verification requirements, unlike the rest of the Delete Act, so there's a conflict there. And then also there are a couple of technical requirements that aren't feasible to meet under the timelines of the bill. So first is the requirement that the system send notifications to the data brokers who respond within 5 days, beginning August 1st, 2026. So push notifications aren't currently a feature contemplated in the DROP design, so the technical and regulatory challenges are too great to meet those by August 1st of next year. And then second, we need to create a secure and confidential exchange in time to meet the March 1st deadline, another deadline that's not possible. So for all these reasons, we believe this bill, while well-intentioned, is flawed, so we recommend a position of neutral if amended to address these concerns. So specifically, neutral if amended, first to place another entity in charge of developing and maintaining the list of elected officials. Second, to establish a verification procedure for the deletion lists. And then third, to adjust deadlines to reflect the technical development required or align the technical requirements with the existing DROP architecture. Slide, please. We'll come back to that one. And then next, AB 322 from Assemblymember Ward. So this is very similar to a bill that the board voted to support in May. However, that one was held in appropriations. The author did find another vehicle for it. A big change to this one is that it now amends the CCPA, so it would fit within the CCPA. We recommend a support position on this bill because it meaningfully advances consumer privacy. Again, it would amend the CCPA at a high level to require businesses to only collect and process enough precise geolocation information that's necessary to provide the service requested by the consumer. It has increased retention limits on geolocation information, and it prohibits businesses from selling geolocation information to third parties. So again, we think this bill is important, as we did the previous one, because location information is extremely sensitive. It provides very specific and sensitive insights into someone's health, political affiliations, sexuality, and therefore requires strong privacy protections. So that's the end of my presentation. I'm happy to answer any questions.
Thank you very much, Deputy Director Mahoney. I believe the board have some questions and comments on AB 302. So Dr. Nanaki, Mr. Worth, Dr. Nanaki, and Mr. Liebert, and then Mr. McTaggart.
Great. Thank you so much for your presentation. For AB 302, I absolutely agree with the spirit and the intent. My biggest question is whether or not this is a duplicative effort. Doesn't the Delete Act already give this right to individuals who reside within the state of California to submit for a request that their data be removed? Number one. Number two, bulk delete requests does not, conform to the requirement that we also need to do verification. So how might we address that? So number one, I think this duplicative effort is something we need to think about. And number two, verification.
Yeah, those are good questions. I think one of the concerns of the author is under the Delete Act, data brokers would have 45 days to process these requests. I think a priority of theirs is having a more accelerated timeline and just having more assistance to the elected officials in making sure they're taking advantage of DROP. But definitely agree with the point that DROP is intended to be very effective for everyone. And then with the verification piece, yes, the author has agreed to work with us to try to address our concerns. So staff is in the process of developing some specific recommendations on verification.
Thank you. Mr. Liebert?
I've seen lots of different descriptions of positions, but I don't recall ever seeing neutral if amended. And I have a lot of friends in the audience, and I don't think they probably have either. And so it's fascinating because obviously what we're all after is if we can address these concerns, I think to be supportive. Although I would like to say that the board members should also be part of the bill to be able to have a bulk deletions of their data. And I say that only partially in jest because I know in my work many years in the legislature that in the world of juries, we started with the approach of saying that law enforcement should not be required to serve on juries. And then for the next 20 years, we went through various proposals of adding all sorts of other folks who should be part of that process too. So I think we have to give some thought to where the long-term this would be in terms of this process. I'm still just a little perplexed in the process that we have right now, because if we go neutral if amended and the author is unable to make those changes that are being discussed, time-wise with the legislative cycle, is that the place that we would end up with in the governor's office, or is our hope that we will be able to, with this great author, resolve these concerns?
That's a good question. I think a big concern of staff and why we didn't feel comfortable recommending, for example, support if amended is, the very late date. This is in the legislative session because of the significant outstanding concerns. Again, the author has said that she wants to work with us to address any concerns. So we weren't, comfortable with an opposed position. Neutral, we felt suggested an ambivalence that we didn't want to indicate either. So neutral if amended as a carefully crafted position to express our feelings.
It's a new one.
Yes.
I just wanted to follow up briefly on that, if it's all right, Mr. McTaggart, which is, I believe we can empower Ms. Mahoney to, in her judgment, go ahead and, of course, take the neutral if amended position, or to take the neutral if amended position, but also to move forward with it should things develop in a way that we could support. And then that puts on us a responsibility as the board to be sure she has good guidance in terms of the kinds of changes that might lead to support. And I really do appreciate the sponsor's office working with us and echo, I'm sure, everyone's view that this is a very important issue. Mr. McTaggart?
Thanks. Do you, Ms. Mahoney, happen to, at the top of your fingertips, remember the details for Daniels Law in New Jersey? That lets me, if I'm a judge, hide all my information totally. But do they have a separate kind of maintained by the DOJ there? Or how does the registry work there?
I know Tom is an expert on this. I'm aware that they did create a separate office within, I think, their Department of Consumer Affairs to deal with this. Specifically, Tom, is there anything you want to add?
Yes, it's called the Office of Information Privacy. It is under the Department of Community Affairs. There's a concept called covered persons in New Jersey that applies to judges and police officers. And what happens is that the covered individuals are able to register. We've gotten some initial data in terms of the size and the scope of that office. The budget is multiple millions of dollars, and a handful of people, at least that's the initial And of course, they don't facilitate the actual deletion in bulk like we would do with this bill, with the Delete Act as well. The other thing is, when talking to other people, just like Board Member Liebert said, well, how about us, right? And so I do think it is important to establish an office that, as the legislature moves forward and decides to have maybe school board, healthcare officials, members of independent agencies that are not elected, I think that could provide a vehicle to facilitate, future deletions, as well as potentially also make requests to state and local governments on behalf of the covered persons to get the data deleted from government records as well.
Thank you.
Yeah, that makes a lot more sense to me than this. And so to the extent that the chair's recommendation is what ends up happening, Ms. Mahoney, maybe just kind of keep that. And it sounds like kind of that's where you were going anyway, but that just strikes me as working somewhere else in another state, and that makes a lot of sense to me.
Thank you, Mr. McTaggart. Mr. Worth?
Yeah, I mean, I'm taking a little further than that. There is no amendment that we're, to date, that we're happy with, right? That we haven't seen anything yet that amends the concerns that we have. What's our stance? I mean, why aren't we more in a position of opposition right now? We've got something that does not belong on our lap that someone's trying to put there. Why aren't we more vocal about, I mean, you're gonna run out of time here, right? So I just don't understand why we're not being stronger against the way it's written today.
So there is a little bit of history that I didn't include in the presentation. So the bill has been changed, at least since it was gotten amended. Before, it was even more concerning in that it wasn't placed within the Delete Act. It required us to submit individual requests on behalf of elected officials. So they have taken some of our amendments to address some initial concerns. For example, moving it over to the Delete Act and focusing it more on the bulk uploads.
We started really bad, then yeah, I don't know. I just feel like we don't want that liability. We don't want that. I mean, what if you miss somebody? What if and what if somebody doesn't want you to be doing this on their behalf? Is that really this agency's responsibility?
Mr. Worth, I think it's because of her title, the author's title, as the chair of the relevant committee. I mean, we should act with that. My own 2 cents is we're acting with, Ms. Mahoney's acting with
Hence the creativity.
Yeah, with creativity.
Let's move on.
There's an urgency to the situation, which also is genuine. I had the same sort of assumption that you did, Mr. Worth, about whether electeds would have a choice. And as I understand it, if I have the right bill text here, of course they change, that it is shall provide each elected official an opportunity to request. So because that was an immediate question I had. Well, hang on, are we just going to opt people out and they don't have a choice? But they would have a choice. Correct. Correct.
That doesn't really
Correct.
say anything.
This covers information. Mr. Laird, is this correct? That this would cover information that for most people might fall under one of our exemptions as publicly available data? Or is it only, no, it doesn't. Okay,
So that's
yes,
one of
then
the
it
things
is.
they addressed in putting it over to the Delete Act, all the existing exemptions in the Delete Act.
Oh, okay, okay. Thank you. I should have realized that. So I think it provides a streamlined way is the idea, right? For people who are seen to be under particular threat to opt out.
Okay, I'll move on. On 322, why was 1355 held up?
I don't know for sure. Appropriations doesn't provide information about why they hold bills. I think, it seemed to be more politically palatable to put it within the existing structure of the CCPA. It might be easier for businesses to, adjust their practices since they've already done the work to comply with CCPA.
Thank you, Mr. Worth. So I could offer a motion to see if anyone would like to make the motion. I do not have a great sense of whether the board would be ready for me to insert into that motion the discretion for Ms. Mahoney to take the position for us that we would support AB 302 with amendments, or if we want to offer her the discretion to go to neutral. I have the sense that Mr. McTaggart might support if it were more like Daniel's Law.
Well, I think we should, in all cases, just say the agency, not the individual, whether it's Ms. Mahoney. I think it should be the team at the agency and delegate authority to the team in the agency to.
Yes, that I thought was implicit, but thank you for clarifying. Yes, Mr. Liebert.
Perhaps the way to do this is to have a support if amended position based upon the discretion of agency staff as to whether or not those amendments have taken, with very clear communication to the author's office. If the amendments are not taken, the agency obviously will have to be in a position to communicate its concerns to the governor's office. And I'm very hopeful that these issues are going to be addressed. I think this idea of a neutral kind of approach is kind of strange for us, frankly, because there are lots of bills that we may be neutral about. And so I think the support if amended encompasses that, which means we will not continue to support the bill if the amendments that are needed in the judgment of staff do not occur. And of course, we have a great relationship with the office, and we'll let them know that the agency will need to communicate its concerns that remain and leave it up, of course, to those who make those decisions.
Thank you, Mr. Liebert. Mr. Worth?
He just said what I was trying to say so much better. Thank you.
Dr. Nonike?
Yeah, can I get some clarification? How does this bill differ from the rights that are already granted via the Delete Act?
Again, I think the big difference is that our agency, would facilitate making sure that if they want to, these elected officials would be able to submit to drop, and then the accelerated timeline, so 5 days versus 45.
If I could be a little contentious, I agree with the spirit of this. I think it's incredibly important. But if we go down this path, shouldn't we also be doing that for victims of domestic abuse? Or where does it end? So I think they already have the right to do this, and they can do that on their own. And delegating that authority to us creates a slippery slope. They have the right to do it, and they have staffers, right, who can submit this information. So I oppose 302.
Thank you. Dr. Nonike? Yes, Mr. McTaggart?
While I respect that comment, I do think that given that we are here in Sacramento and the legislature is right next door, I think it would behoove us to try to cooperate if we can with their efforts. And so I really liked Mr. Liebert's concept of support if amended. I think that's a nuanced kind of view, and it allows us to communicate, hey, we're going to have to go. I love the sort of behind, what we are not going to come out publicly and everything, but we'll go to the governor's office and explain why this is impossible. I totally agree with you, Dr. Nonike, about where does it end? And I think that what I've heard a little bit from Ms. Mahoney is it's the urgency and it's the timing and it's a requirement that we do it. And so potentially there's a middle ground that's more palatable. I just, the author is the chair of the Consumer Privacy Committee, and I think it behooves us to try to work with the author if we can. So I would support Mr. Liebert's concept.
Thank you. My tendency would be not to take neutral if amend off the table in order to give the team flexibility as they need. But I'd like to ask Ms. Mahoney's thought on that. What would be most useful to your team?
I'm comfortable with either position. I feel like either gives staff the flexibility to work with the author who has indicated that they do want to.
Right. Okay. Mr. Worth.
I think it's a better approach because what you added, what I tried to add, people didn't understand what you added, is important. So even if we stuck with neutral, we have to have the other leg of this that we would oppose it if not amended. So I would prefer to have support as the other option.
So we are currently neutral, and there will be authorization to move to support. Does that reflect? Okay. If amended, of course, yes.
We get to review amendments before.
Yes, well,
you.
yes, the agency through Ms. Mahoney's team.
Okay.
All right. Further comments on AB 322? All right. In that case, to preview, before we take public comment, I will request a motion actually, we could put the motion on the table and request public comment. To authorize agency staff to support AB 322 and to take a neutral position and hang on, I'm not done yet. Support if a neutral, I've got to start over now for the transcript. To authorize, a motion to authorize agency staff to support AB 322 on behalf of the agency, to take a neutral position on AB 302, but authorized to move to support if amend, should the bill incorporate staff's recommended amendment criteria, excuse me. And further, to authorize staff to continue to maintain these positions if the bills are amended, if in staff's discretion the amendments are consistent with the objectives set out in our discussion today and the memos before us, and to authorize staff to remove support for or support or oppose these bills if amended, if in staff's discretion they're no longer consistent with the objectives set out in the materials and stated today by the board. Does anybody want to go ahead and amend that motion, suggest amendments, or make the motion?
I'll just say I'm confused.
Okay.
I just want to be clear that on 322, the motion is actually to move to a support if amended position.
322 is the location data.
The 302.
I believe it was recommended that we support it.
Support if amended.
Just support it.
No.
This is the location data bill.
I'm not talking about location data.
That's 322
Okay.
you're talking about.
Yeah.
Okay.
That's support if amended, right? I just want to make sure we're.
Well, my understanding was we are neutral right now, but the staff has the discretion, but you want to be supportive amended right now. That's fine. Okay.
I guess my point is we're not neutral right now. We support if amended.
Okay.
If not amended, then we will raise concerns.
Okay, fine.
Is that cool?
Let me restate. Request a motion to authorize agency staff to support AB 322. This is backwards in my notes. It's not your fault, Mr. Liebert. To authorize agency staff to support AB 302 and to take a support if amended position for AB. I was right the first time? Oh, good Lord. We'll take a break after this. And also, kudos to the legislature for dealing with dozens and dozens and dozens and dozens of these bills and keeping all the numbers straight. I will request a motion to authorize agency staff to support AB 322 and to take a support if amended position on AB 302, incorporating staff's recommended amendment criteria. And furthermore, to authorize staff to continue to maintain these positions, even if the bills are amended, if, in staff's discretion, the amendments are consistent with the objectives set out in our discussion today and the materials before us, and to authorize staff to remove support for, support, or oppose the bills, if amended, if in staff's discretion, they're no longer consistent with the objectives set out in the materials and stated today by the board. So that last bit's a little bit of belt and suspenders since we have a simpler position at the beginning. So that would be the motion, which of course can be changed if people need it to. Yes, Mr. Liebert.
I just need to recuse myself from 322.
From three, oh, should we split it then?
I think that's what we have to do.
Okay, Mr. Laird, if Mr. Liebert needs to recuse from 322, then we should split it, I think, which is fine. But let's take public comment first.
If you'd like to make a comment on legislative update and CPP positions on pending legislation, please raise your hand using the raised hand feature or by pressing *9 if you are joining us by phone. This is for agenda item number 4. It looks like we have somebody in the room who'd like to make a comment.
Good morning, Danny Kando Kaiser. My firm Kaiser Advocacy works with a number of privacy groups. This comment is specifically on behalf of Consumer Reports. Commenting on AB 322, thanks for the opportunity to speak with you, and thank you for the agency's work on advancing privacy. Consumer Reports appreciate CPPA staff's proposal to support 322. Legislation that would ban the sale of consumers' precise geolocation data. This is a critical baseline protections will take the burden off of consumers to protect their privacy. As the board is aware, location information is one of the most forms of personal information that exists. It can reveal where we worship, which doctors we see, the location of children, when we are at a protest, and more. And collected and sold without the full awareness of consumers and is then often used against them. For example, data brokers often sell consumers' whereabouts to anybody with a credit card, play out with dire consequences in the attack last month. The sale of this information can also enable scammers and predatory pricing tactics. AB 322 would help protect us from these abusive practices by banning the sale of our location information and by prohibiting companies from collecting or using our location unless they need to do so to provide the services we have requested. This should not be a controversial idea. The weather app on your phone may need to access your location information to give you a forecast and be selling that to data brokers behind your back. With recent events, we've seen several states around the country move to support similar protections to the ones in AB 322. Oregon and Maryland have enacted similar prohibitions, and lawmakers in Massachusetts are currently considering the same. Finally, this bill would advance the purposes of CCPA and the agency by strengthening protections for a key piece of sensitive information, a goal that we think is well worth supporting. Thank you.
Thank you for your comment. Ms. Carwile, is there further public comment?
This is for legislative update and CPPA positions on pending legislation. If you'd like to make a comment at this time, please raise your hand using the raised hand feature or by pressing *9 if you're joining us by phone. This is for agenda item number 4. Madam Chair, I'm not seeing any hands raised at this time.
Thank you very much, Ms. Carwile, and thank you to the commenter. With that, I've had a chance to reset my brain a little bit, and I'm going to split the motion that I suggested into two to accommodate Mr. Liebert's recusal. So to begin, I'd like to request a motion to authorize agency staff to support AB 322, which refers to precise location data, and to take, darn it. Okay, this is the charm time. To authorize agency staff to support AB 322, and furthermore, to authorize staff to continue to maintain the support position even if the bill is amended, if in staff's discretion, the amendments are consistent with the objectives set out in the materials before us today and our discussion today, and to authorize staff to remove support for or oppose the bill if an amended staff's discretion is no longer consistent with the objectives set out in the materials and stated today by the board. Would anyone like to offer this motion?
So moved.
Thank you. I have a motion from Mr. Worth.
Second.
I have a second from Mr. McTaggart. Ms. Carwile, could you please conduct the vote?
Yes, Madam Chair. Board Member Liebert? Okay. Board Member McTaggart?
Aye.
Board Member Nonecki?
Aye.
Board Member Worth?
Aye.
Chair Urban?
Aye.
You have 4 yeses and 1 abstaining.
Thank you very much. The motion carries with a vote of 4 and 1 abstention. Thank you, Ms. Mahoney, for that. I now will request a motion to authorize agency staff to take a support if amended position for AB 302, incorporating staff's recommended amendment criteria. And furthermore, to authorize staff to continue to maintain this position even if the bill is amended, if in staff's discretion, the amendments are consistent with the objectives set out in the memos before us today and our discussion today, and to authorize staff to move to a support position or opposition position if the bill is amended in such a way that in staff's discretion, it is no longer consistent with the objectives set out in the materials and stated today by the board. May I have such a motion?
So moved.
Thank you. I have a motion from Dr. Nonecki. May I have a second?
Second.
Thank you. I have a second from Mr. McTaggart. Ms. Carwile, could you please conduct the vote?
Ask you a question.
Please go ahead.
So we said we could move to an opposed position if amended. If it's not amended, what's our position?
It's
Opposed, right? So it doesn't need to be amended only for us to oppose it. If it's not amended, we have an opposed position, don't we?
We haven't officially taken an opposed position on the bill.
I thought that's what was recommended. It was by me. I thought you did as well. So
It was support. It's support if amended, which doesn't necessarily.
Well, this is kind of the nuances of the legislative process. And that is that if we say support if amended, and the author doesn't take the amendments, and we make clear to the author that without the amendments, the agency will need to be communicating its concerns to those who will be making judgment on the bill, that is still something consistent we can do without going formally opposed, or we can go formally opposed. That's a,
I don't, it's,
Yep.
the wording doesn't matter to me. It's just,
Yep.
so as long as we have an understanding or add that to the motion that if not amended or amended in a way that
Yep.
is not consistent, we may voice concerns.
Yeah.
You did really?
Ms. Mahoney, do you think you have the discretion to do everything the board just discussed? And I'll also look at Mr. Laird to be sure. I can also restate it to be very, very clear that if the amendments are not consistent, I mean, it's really up to you. I think this covers what Mr. Liebert laid out, but I of course want to be sure that this is correct.
I'd agree that the motion is stated. Give
Okay.
staff that flexibility.
Thank you. Mr. Worth, is that satisfactory? All right. Ms. Carwile, could you please conduct the vote?
Board Member Liebert?
Aye.
Board Member McTaggart?
Aye.
Board Member Nonecki?
Aye.
Board Member Worth?
Aye.
Chair Urban?
Aye.
Madam Chair, you have 5 yeses.
Thank you very much. The motion carries with a vote of 5-0. And I'm sure staff look forward to, and I look forward to staff working with the author's office on this very important issue, and generally with the legislature on all their good work in this area this session. Thanks very much. And again, thanks again to our public commenter. I obviously need a break. And so I'm going to suggest that we take a break of, folks tell me what you need. 10. Okay, a 10-minute break, and we'll return at 11:15 to take up agenda item number 5. Wonderful, thank you. Welcome back from break, everyone. Thanks to the board and the public for their efforts on our agenda items so far. We will now move to agenda item number 5 for today, which is discussion and possible action on proposed regulations regarding automated decision-making technology, risk assessments, cybersecurity audits, insurance, updates to existing regulations, including the adoption or modification of text. And it will be presented primarily by members of our legal division, our general counsel, Mr. Philip Laird, our senior privacy counsel and advisor, Ms. Lisa Kim, attorney Kristen Anderson, and attorney Nilofer Sheikh. Mr. Kemp will introduce the topic and remind us of the timeline. Mr. Kemp?
Great, thank you very much. Thank you. As you all know, after several years of developing the regulations related to ADMT risk assessments and cybersecurity audits, the board is in the final phase of completing the rulemaking. With the meaningful and significant revisions the board made to the regulations after considering the comments submitted during the approximately 90-day public comment period, the regulations strike an appropriate balance between consumer privacy and the operational requirements placed on business. As a reminder, these modifications included, among other things, phasing in cybersecurity audits and requirements by businesses' annual gross revenue over a 3-year period, removing the behavioral advertising threshold for ADMT requirements, and revising the ADMT regulations to focus on the use of ADMT for significant decisions. These modifications, among others, have simplified implementation and costs for businesses to comply with the new requirements while still fulfilling our mandate under the CCPA. Specifically, in regard to cost, the board's modifications have reduced the economic impact of the regulations. Direct costs to businesses have been reduced from the original projections of over $10 billion to $4.8 billion over a 10-year period. Cost to businesses rapidly declined by over 52% in year 2 and down 81% by year 10. At the same time, net benefits to businesses are positive 1 year after implementation in 2029, and total benefits increased by approximately $90 billion over a 10-year period. Now $282 billion, previously $192 billion. I'll note that the increase is due in part to a helpful comment received that pointed out a math error, revealing we actually underestimated benefits in our initial proposal. In addition, job growth is positive by 2035, with significant increases to more than 300,000 more jobs in California by 2037. Impact to gross state product is positive by 2034 and significantly higher at over $300 billion by the 10th year. As such, the agency has developed regulations taking into account the voluminous feedback from stakeholders and concerns of the regulated community while complying with its legal obligations and staying within its delegated authority. By adopting these regulations, the agency can monitor how the regulations are working for the industry and consumer vis-a-vis our privacy mandate and more quickly make adjustments based on that data in the future. General Counsel Laird will now address the rulemaking process.
Thank you, Mr. Kemp.
Thank you, Director Kemp. So after the revisions made by the board at the last meeting, the agency commenced what was the minimum requirement was a 15-day public comment period. We actually offered 24 days to the public and even additional notice given that the text was issued even earlier than the release of the notice regarding those modifications. And in response to this request for comment, the agency received approximately 575 pages of comments from 70 commenters. Staff has carefully reviewed these comments and does not believe additional changes to the regulations are necessary at this time. And I'd like to emphasize that this is precisely how the process is designed to work. Each time the board considers a proposal, a draft of the text, we then turn to the public, receive their feedback, and then we return, giving this board the opportunity to then make a decision. Have we got it right? Are we ready to adopt, or do we need to further modify? So as a reminder of the history that's brought us here, I know Mr. Kemp touched on it. I'd just like to dial down a little bit further. The agency really did engage in robust communications with a wide variety of stakeholders to develop the regulations to this point. Preliminary rulemaking activities on these topics began in 2021 with an invitation for public comment. The agency received and reviewed back then nearly 900 pages of public comment in response to that invitation. The board followed up with several pre-rulemaking informational sessions in spring 2022, and in 2023 and 2024, the agency continued with additional pre-rulemaking via an invitation for written comments and several public stakeholder sessions. Now, after gathering public input and several board discussions on this package, the agency started the one-year formal rulemaking process on November 22nd last year of 2024. And at its last meeting, the board voted to have an additional comment period on the modifications to the rulemaking package. The modifications addressed many concerns raised by industry and the public, as stated by Mr. Kemp. Additionally, the regulations as currently proposed are consistent with both the CCPA and the Administrative Procedure Act requirements. Now, if adopted, the board materials will next be submitted to the Office of Administrative Law. The submission will include the text, the final statement of reasons, a revised Form 399, along with the comments, a summary of the comments received, as well as all other documents considered during the rulemaking and responses to public comments provided as well. We recommend that the board adopt the regulations as currently proposed and direct staff to submit the final regulatory package to the Office of Administrative Law for approval. It is important to note that regulations only become final after they're approved. OAL has 30 business days to make a determination about the regulations. And so with that, those are the sort of prepared remarks we have up front today. We're ready to turn the discussion back to the board. And again, as mentioned, I'm joined today by my esteemed colleagues, Ms. Kim, Ms. Anderson, and Ms. Shake, who I'd be remiss to not just praise how impressive they've been at working through these very complex issues and preparing some top-notch documentation to support this initiative.
Thank you very much, Mr. Kemp and Mr. Laird. I would like to know if the board have comments or questions on this item currently. Mr. McTaggart and Mr. McTaggart.
Well, so first I want to just acknowledge the marathon this has been and the amount of work you guys have put in. It's been extraordinary. Every time there's one of these comment periods, you know, it's one thing to hear 500 pages. It's another thing to have to go through every single comment and review it and assess it and put it in a bucket and kind of figure out what the ramifications are. So I just, you know, it's been a long process and we're close to the finish line here. So congratulations. One question for, I don't know who on the team, you know, I sort of, a lot of the comments kind of fell into sort of certain buckets. You know, people were worried about different things. And I guess one question is, you know, in conversations with you, I feel like sometimes the concerns are overblown, but I can understand where the concern comes from. They're sort of saying, well, if you interpret it this way, this is going to happen. And so I'm just wondering whether it would be possible to produce some kind of a guide of like, this is why you shouldn't be this worried about it, because this is how we think it. We don't think your interpretation, your worry is this bad because this is how we look at it. And, you know, might be something that you guys could produce as a team.
Yes, thank you for that comment, Mr. McTaggart. Absolutely. And I will say I totally agree. I think many comments we received demonstrated sometimes misunderstanding of actually what the regulations state, at least from staff's perspective. And as part of the rulemaking process, we will be further producing in our final package those summary and responses to every public comment. And with those responses, we do aim to be thorough and address the issues, clarify misunderstandings, and be intentional with how we explained our position on these requirements.
Well, I think that would be really useful. And it's kind of not just because of that, but one of the reasons I'm a strong supporter of moving forward now is just because I'm having talked, you know, having communicated with you, I feel like some of the concerns are not warranted. And I think this is a streamlined, thoughtful set of packages, a set of regulations. And I just want to remind everybody that nothing's written in stone. Like if something turns out not to be workable, that's why we have such a competent team. We can always kind of come back and reevaluate it. But there's a real, it's 2025, you know, this thing was passed in 2020. Let's move forward and remove a lot of uncertainty from the regulatory process. So I'm going to be a strong supporter of moving forward today.
Thank you very much, Mr. McTaggart. Other comments? Yes, Mr. Worth.
It's funny, you mentioned the 500 pages this round. And I think when you first stated was, we received 500 pages of comments and we don't think we need to make any changes. Well, we've had years of comments and changes being made. There's a few that I would like to go through with you real quick. And I want to make sure, you know, on one case with that, we have the same understanding. We saw some folks ask us to pause as it relates to Article 12 because there's a SB 354 that's working its way through the system. Back to what Mr. McTaggart just said, if we later on find there's something else out there or things need to be changed for any reason, these can be changed and amended in the future.
That is correct. And I'd also point out the thoughtfulness by this board on delays in implementation actually give us runway to see if there's any change in structure and actually make changes even in advance of the effective date of these regulations necessary.
There was a comment I'm trying to find, I mean, you probably know where it is, but there was a comment related to a term called sensitive locations, and it referenced that we're creating a new requirement. And I was just trying to get your opinion on that statement.
Yeah, I appreciate that. One thing I'll just start with, and then I'm going to turn to my colleagues here, is if we recall, the requirement actually originated with this concept of public profiling generally. And we received a number of comments concerned that that was maybe an overly broad standard that was being utilized in these regulations. And so what you saw in the modifications was a narrowed version of that standard. And with that said, I'm going to actually ask Ms. Shake and Ms. Anderson to follow up.
Thank you. Yes, with respect to the term sensitive location, that is simply a shorthand we use just to shorten the actual length of the threshold in 7150B5, but it is not a new category or new term that we're adding. It is simply clarifying the types of personal information that where the processing based off of where someone is, these particularly sensitive locations present significant risks to their privacy. So it's not a new type of sensitive information, rather it's a clarification that this specific use of personal information and these types of inferences, which are a type of personal information, are a significant risk and do require risk assessment.
I just want to point out that you quoted the section from memory, which I think actually, no joking aside, that kind of shows the amount of effort and dedication and thoughtfulness that's gone through all this. So I echo Mr. McTaggart's comments that I think we've done a great job to get here and it's time to move forward.
Thank you, Mr. Worth. Mr. Liebert.
I'm never one to miss an opportunity for a speech. I first want to emphasize some of the points Mr. Laird gave in his remarks and just really express my admiration for all of the board members who have put so much work into this. I don't think anyone can reasonably suggest that this agency and its incredibly diligent and impressive staff have not spent sufficient time grappling with the incredibly complex and complicated issues surrounding these proposed regulations. I can't imagine how many staff hours have been dedicated to this work, reflecting that you can cite this by statute now in every code section. It's amazing. But I am certain it's literally many hundreds, if not thousands of hours. I found these public servants to be some of the most impressive I have dealt with in my, I think it's 4 decades now of public service, and I thank them for their impressive work and diligence. This board itself has been actively considering these regulations, as you've all noted, since 2021. That's not a fast process, by the way. Years before I joined this effort, that's almost 4 years ago, and yet we're still here today considering whether we've appropriately dialed in these requirements as best we can, reflecting great effort by this board and its great chair, and the staff to strike the best balance possible between minimizing costs imposed on our great business community while maximizing consumer privacy protection. And talk about due diligence. By my review of past records, this board has actively discussed these topics and these regulations over the course of more than 10 meetings. We've received well over 3,000 pages of public feedback, more than I can read. And staff has prepared hundreds, if not thousands of pages of documentations again and again and again to explain and provide the basis for the details of this extensive proposal. Reflecting this care and diligence, the agency has contracted with world-renowned economists to do their best at estimating the potential costs and immense benefits of these complex regulations. This is challenging and novel work. Everybody's doing the best they can. I also believe the agency has been as nimble and responsive as possible to both the public's feedback as well as to the understandable concerns of the great businesses in our state. And of course, to our friends across the street in the legislature and the governor's office. We very much care what they're up to. There's no question that we and our staff have listened carefully to all of those folks as we try to strike the right balance. I suspect both perspectives from all sides will still have a lot of unhappiness. And it's totally understandable. Businesses are under stress, just as consumers are. I don't think that our test can be as everybody happy, that's for sure. We're doing the best we can in this balancing approach. Finally, I want to take us back to 30,000 feet, which is where I like to hang out. The fact is, the voters of California created this unique state privacy agency, thanks to one of our board members, with a mandate to do this work and strive to make meaningful progress in protecting their privacy. This was not an optional exercise for this board or its great staff. I'm sure if we had given you a vote, you would have said, I think we'll pass. We were required to do our best and to keep improving these regulations, and we will do so. If we've made mistakes, they're so complex, I'm sure we will take that option to try to improve them, both to protect our business community and to protect our voters. With all that in mind, I support adopting these thoughtful and I say balanced and privacy-focused regulations today. But I also want to make one thing clear, we're not done. This version of the regulations really sets a clear floor. We've been going down over time to try as best we can to respect and reflect those concerns that have been raised. We've got the authority to make it better, but we also have the duty to do so. To our friends dedicated to enhancing the privacy of all Californians, I remind them that this is the beginning of the effort. We will be vigilant, absolutely, and we've got this great staff to tell us, is this working? Are we making a difference? Are we living up to that statute that is really so much a landmark? We are indeed doing what California's always done. We are leading the country in this. And for those privacy groups that we have so much respect for, if these regulations move forward today, we are at the front of the pack in the country on these issues. And we need to remember that. We are not perfect, but we're starting the journey. To our friends in the state's great business community, I remind them that we really have listened carefully to you. If you look at the progress that's been made over these many months, great changes have been made. We don't expect everybody to be thrilled with the fact that they're going to have to pay some money to help protect the privacy of their customers. We totally get that. The reality is that protecting privacy has substantial costs. But losing our privacy so often costs so much more. And the only way we typically find that out is when we really find out that our identity's been stolen or we personally feel harm. But we are all harmed when all of our sensitive personal information is out there. And we need to take the steps that the voters told us to take and to start making real progress in this. So I applaud all the work that you've done. And I am very happy to join my other board members in moving forward with these regulations.
Thank you, Mr. Liebert. Sure, Dr. Nanaki.
I would like to echo my fellow board members and that this is an outstanding Herculean effort. Looking at all of the comments and the feedback you have all integrated is quite admirable. I have a follow-up question, though, about the implementation of risk assessments. As I read it, risk assessments happen as the model is being developed, and then they are also reported. One of the concerns I have is that if you have one of these models learning from data and using reinforcement learning, and especially if the public or consumers are inputting data, which sometimes they might be inputting personally identifiable information that not necessarily the provider of that service requested. That model, if it is using reinforcement learning, might learn over time, I'm going to use this sensitive personal data to make decisions. So one thing I would like more clarity on is how do we ensure that these developers or deployers of these systems are implementing risk assessments at appropriate intervals and reporting?
Thank you for the question. So yes, the timing requirements for risk assessments are in section 7155 of the regulations. But really taking a step back, risk assessments we see as continuing throughout the life cycle of the processing activity. So it's not simply that you do it before the activity begins and then you can wash your hands of it saying like, I've checked the box. That is not the case with these risk assessments, nor is it the intent of the regulations. And a business generally will update their regulations in two situations. So one, the board built in just a 3-year timeline for businesses always to review their risk assessments for accuracy and update them as needed. So that becomes a fail-safe if they have not already updated it. And then the second is if there's a material change to the processing activity that will either diminish the effectiveness of the safeguards that they've implemented or create new negative impacts, they would have to update the risk assessment within 45 days of that change. And so there are two different update timelines built in that, again, is intended to encourage businesses and facilitate their ongoing identification and mitigation of risk throughout the processing activities. And of course, we're going to continue to monitor these regulations in the marketplace to see if this is effective, if changes need to be made to the regulations to adapt to the types of processing activities that you've mentioned.
Yeah, and thank you so much for pointing that out to me. I see here now the 3 years and then also the material changes made. For me, 3 years seems like a pretty long time. And if they don't audit, they don't know. They don't know if, the model is now loading onto PII in ways that they didn't intend it to. And so my worry is that over a 3-year span, you might start to see some of these decisions being made in ways that they didn't want them to be made. But at least, it would be caught within the 3 years. But that is a concern for me, the timeline.
One of the things we do in the regulations is we do try to provide guidance about what types of material changes, including, for instance, complaints by consumers about the types of harms that you've mentioned. Those could be a trigger for a material change. But again, we'll continue to see whether or not additional guidance is necessary to address the types of scenarios that you've mentioned.
Thank you, Dr. Nanaki and Ms. Sheikh. And I want to second what Dr. Nanaki said about the inherent uncertainty here. Tell me if I'm wrong, but I understood you to be describing a scenario where the change might be invisible to the consumer and to the company should the company not look. And I think this is something we definitely will want to monitor and keep an eye on. So thank you. Other comments and questions? I also want to express my appreciation, not to say exhaustion, sincere appreciation with the dedication of so many people over now 4 years in 2 months' time to develop these regulations, some components of which were the first versions of themselves in the country, although other states and other efforts have indeed begun to also to operationalize the components of what we have been working on. And of course, other countries have served as models as well. As the last remaining standing person who started the process of the regulations, when we did not actually have staff, we didn't yet have an executive director, I just want to express some sort of gratitude, thanks, and compliments to a number of people who have been involved in this process. And that includes, thank you, Mr. Liebert, for recognizing the board, the dedication of the board. The board is a living entity that evolves over time. And I want to recognize board members who are no longer on the board, who poured a tremendous amount of thought and care into the regulations at an early stage. That includes Mr. Chris Thompson, and especially Ms. Lydia de la Torre and Mr. Vincent Lay, who were on a subcommittee together to help produce the first draft of the regulations, this package of regulations that we saw, and who brought concepts to the board and to the public beforehand, as well as multiple drafts of those regulations. And so I want to thank them for their work. The legal division team has been beyond impressive. I second Mr. Liebert's comments about the quality of their work, the consistency of their work, the amount of their work, the clarity, care, professionalism, and skill that has gone into this process is stellar, and it really is, sometimes I have to write recommendation letters, and judges really want a quantification, which is baloney, because you can't really quantify these things. But I mean, it's in the top 1% of work I've seen in this highly specialized area. And especially because this is the board, I want to thank you for your incredible preparation, knowledge, and clarity in answering our questions, some of which came out of left field, I know, and it never looked like that in your response. It's just been an absolute pleasure and honor to work with all of you through these many iterations. And I want to thank the public. You know, I think that there's certainly a wide range of views. Sometimes they're very divergent, and they're divergent on topics from the level of the detail of, as Mr. Worth was asking about, what is relevant sensitive location information for a certain threshold, to should you do it at all. And participants from the public have been equally dedicated, in my view, in making their views known. Yes, we have to read the 3,000 pages of comments, but it's the public who have to rate them. It's the public who show up here to talk to us. It's the public who show up on Zoom. And the care and dedication of the staff and of the board in listening to those comments has improved the regulations immensely. It's been a group effort, which is what a regulatory effort should be, to implement the will of the voters. The voters who, as Mr. McTaggart pointed out, in 2020, voted for this and to tell us to implement their requirements. So I know that we have ended up in a place that isn't exactly what I would like. I do worry about some of the timelines for the cybersecurity audits. For example, there was a 0-day attack on Monday that affected the entire ecosystem. And so I would really like to encourage companies to maybe, get a jump on that timeline because it's good for the ecosystem. I'd like to remind everybody that the costs are underestimated. They are only the direct cost to businesses implementing. They're not the costs to consumers, to the people whose information, identities are stolen. As Mr. Liebert said, the benefits are direct as well. And so I would like to ask everybody to continue this spirit of participation in building these technological systems in a way that's that it benefits all Californians and creates an excellent and competitive business landscape in the tech space with regard to privacy and cybersecurity. I'd also like to say a word with relation to the comments from another sort of group of viewpoints, crucially important, who represent the public, who represent workers, are the public individuals themselves, are workers themselves. Some of the comments have expressed disappointment in, for example, some of the thresholds changing. Here I emphasize again what has been said. This is a floor. This is something for us to work with, for everybody in the economy and in the public to sort of test out. And I would charge the board with making sure that we maintain our eye, keep our eye on how the regulations are operating in the field so that we can consider carefully and be ready to address harms that are continuing or that are getting worse that we have not addressed yet in the regulations. To all of the commentators, Mr. Lieber is exactly correct. We can't make everybody happy. And indeed, our job is to do the best that we can in order to implement the law in the interest of the broadest swath of Californians. But we hear you, and we are listening, and we want the regulations to be as the very best that they can, serving all of the interests while keeping our eye on our mission to protect the fundamental privacy rights of Californians. So keep commenting. Work on implementing the regulations. They are strong, they are reasonable, they are clear, because our staff is amazing. And we will keep working on this endeavor. That would be my pledge to you as well. So I want to name just a few people besides the board members on the staff. Ms. Sheikh, Ms. Anderson, Ms. Kim, Mr. Laird. Again, your work has been stellar. And I want to also thank our inaugural executive director, Mr. Ashkan Soltani, whose expertise and dedication kind of knows no bounds, and who was incredibly helpful and influential to the process. If it's not clear, I support staff's recommendation on these regulations. So thank you very much. Other board comments are welcome, and if not, we'll take public comment. Wonderful. Public comment. Is there public comment, Ms. Carwell?
If there's any public comment from those who are here in person, you can line up behind the podium. This is for agenda item number 5, discussion and possible action on proposed regulation regarding automated decision-making technology. Let's just make sure. Risk assessment, cyber audits, insurance, and updates to existing regulations, including possible adoption or modification of text. You'll have 3 minutes. Go ahead and begin when you're ready.
Thank you. Good afternoon, CPPA board members. Join Kennedy, California Hispanic Chambers of Commerce, and as you know, our organization comprises 130 Latino and diverse chambers of commerce and business associations representing the interests of California's over 1.5 million diverse small businesses. On behalf of our members and the constituents we serve, we appreciate CPPA's efforts to collaborate with us in addressing our concerns regarding the CPPA regulations. We support the following that is before you, the regs that are before you today. Specifically, the new definition of automated decision-making technology, the removal of behavioral advertising from ADMT and risk assessment, and of course, deletion of references to artificial intelligence from the CPPA regulations. Additionally, we request that CPPA establish a single compliance date for all regulations, including ADMT, cybersecurity audits, and risk assessment regulations. As we all know, California is facing several economic challenges, and its small businesses need every possible form of economic relief. This includes having one compliance date for all CPPA regulations. Based on the current draft regulations, we believe CPPA has made significant strides in the right direction. Finally, I wish to thank the board and, of course, the CPPA staff for all their hard work in putting these regs together. And I thank you for considering today's testimony, but also our past comments that we've made before you. Thank you.
Thank you, Mr. Kennedy. And Mr. Kennedy, you are someone who has been stalwart in commenting through the process. Thank you for that. Please go ahead.
Good morning. My name is Annette Bernhardt, and I direct the Technology and Work Program at the UC Berkeley Labor Center. I want to acknowledge the hard work of agency leadership, staff, and board members on these regulations in a difficult and fast-changing policy environment. That said, we are deeply disappointed at the substantial weakening of the proposed regulations and, frankly, at the lack of responsiveness to our coalition of 70 labor and civil society groups, which represent hundreds of thousands of workers and consumers. Our organizations have invested significant time over the past 2 years analyzing draft regulations, gathering evidence, writing responses, and giving public comments, all with limited resources. And I will say we have done so quite capably and with full understanding. And yet none of the recommendations in our January 9th, 2025 letter were adopted. Similarly, the principles we articulated in our February 26, 2024 letters are absent from this draft. Instead, each iteration of the proposed regulations has conceded more and more to the concerns of the business community and the tech sector. As a result, it is our empirically based assessment that the current proposed regulations do not provide the protections that consumers and workers deserve under the CCPA, and that the law itself clearly intended. Specifically, as detailed in our most recent coalition letter, 1, definitional changes leave large swaths of workers and consumers unprotected by the proposed regulations. 2, the revised notice and data access regime will not work for workers and communities. 3, the revised ADMT opt-out provisions have become even more inaccessible to workers. And 4, the risk assessment requirements have become weak tools for identifying and addressing ADMT harms. In sum, the revised regulations, in our opinion, fail to meet the spirit and substance of the rulemaking charge that was given to the CPPA by voters, particularly in the area of automated decision-making technology. This is a profound lost opportunity, especially for workers. The emergence of data-driven technologies represents one of the most important issues that will shape the future of work in California for decades to come, affecting workers' privacy, wages, working conditions, race and gender equity, right to organize, and autonomy and dignity. We strongly urge Executive Director Kemp, agency staff, and board members to reconsider the current trajectory of the proposed regulations and revert back to the intent of California's privacy law and the state's voters. Thank you so much for the opportunity to comment.
Thank you, Dr. Bernhardt. Ms. Carwile, I realize I apologize 1 second. I just want to be equitable when it comes to commenters on Zoom and commenters in person. So I propose that, are there commenters on Zoom?
Currently, we have 4 people who will be
Okay.
commenting on Zoom.
Okay, wonderful. So let's continue with comments in the room for now. And at some point, please forgive me if we move to Zoom for a comment or 2 and then move back. Thank you. Please go ahead.
Morning, my name is Dariush Mubarake, and I'm a driver working for Uber, and I need this work to support myself and my family. And yet the corporation uses my data to make arbitrary decisions about me. If the app's AI decides to deactivate me, I can go months or years without being able to work due to an arbitration automatic decision. The app also uses my data to decide how much to pay me and when to send me rides. I often work for 12 hours straight without time to sleep or eat. This means that whole life and the future of my family depends on the data that these corporations hold on me. But I've struggled to win access to my data. CCPA opened a door that allowed me to fight for my data, but it hasn't been easy. I've struggled to get these app corporations to show me what kind of data they are holding. Are they recording my conversations? Are they tracking me on and off the job? Why did they decide to deactivate me? Based on what information? I've given years of my life to this app. and I have the right to know what data the app has been harvesting on me. And I have the right to know how that data is being used. We should be making the CCPA stronger, not weaker. We should be making CCPA stronger, adding more oversight and protection for the workers and consumers, not weaker. CCPA gave me hope that I could see my data, and now these changes are taking that hope away. This is a clear issue. Are we on the side of the workers and consumers, or on the side of the big corporations? This is a fight for truth, for transparency, for the right to know who is watching me and what they are doing with my data. When we say data, what are we actually mean is my life, the content of my life, my work, the future of my family. That's what my data is. Every day in my car, every sacrifice I make to feed my family, every hour I stay awake. This is what is being squeezed mine for every drop of data. I want access to my life. I want access to my story. I want access to my data. Thank you.
Thank you very much.
Hello, my name is Ivan Olivo. I'm a rideshare driver for Uber and Lyft. I've been a driver for many years. I've seen many things that these companies have done to drivers, including myself. And one thing that we've all been seeing very recently, and it's in all the news, it's on the press. We have AI, we have automation. This new world is coming, but at what expense? Are we really truly benefiting our communities? The human aspect, and that aspect is now being removed. And not only being removed, but also being used against us. So this supposed technology is, here to help, so to speak, but really it's basically giving these corporations more control, more ways to manipulate, more ways to actually earn a profit for their shareholders, and at what expense? It's bad enough as drivers, we continuously get lesser and lesser and lesser pay, while they charge all of you, who I know all use rideshare, more and more and more money. Yet, who's the winner here? It's the corporations, right? They don't care about us or the human element anymore, to the point where they want to put this AI technology forward to manipulate us and to put us in a position where we can't even defend ourselves. There's no human element, there's no investigations when we're being accused of something. Most of these customers and so forth that know about the system know how it's being manipulated, and they just simply want a free ride. They say, oh, that driver, I smelled alcohol in his breath, or I smelled marijuana or something when I was in the car, whatever. Oh, no problem. We will go ahead and credit you on that ride, and we'll take care of the driver. And what happens to the driver? There's no investigation. There's no who did what. There's no, I have video evidence in my car that proves that whatever I'm being accused of is false. The AI just takes care of it. You're off the platform. And then we supposedly did an investigation, which never is disclosed on whatever that investigation was. It was just simply a computer saying, we have plenty of other drivers, we're just going to put in that guy's place, and we don't need him anymore. He's disposed, regardless that I had a 5-star status, regardless of how many years I've been, regardless of how many comments, regardless that I accepted 99.9% of, let's be honest, some of the crappiest rides where I literally am making $3 to drive half an hour somewhere. $3 to take a human in my car? Not to count all my expenses, all my wear and tear on my vehicle, my time, my gas. It's like slave labor as it is right now, and now they want to impose this onto us? Like, where does this stop? Where is all this going to stop? I'm hoping it's going to stop with you guys. I mean, you guys are like the last defense. I mean, we've suffered enough, you know what I mean? So I really, really hope that you consider this, and to listen to these drivers and to listen to the people, right? We're representing the people, and this is who it affects. So I really appreciate your time. Thank you.
Thank you very much. Let's take one more comment in person for the moment, and then we'll take a couple comments in Zoom, and then we'll come back.
Good afternoon, board members. My name is Cesar Palancares, and I'm the lead organizer with Gig Workers Rising. I stand here before you today to urge you to protect the CCPA and protect workers from unchecked risk of automated decision-making systems. Algorithms are increasingly deciding who gets hired, who gets fired, who gets suspended, and whose performance is deemed as not meeting standards. These systems often lack of meaningful human oversight, the consequences for workers are tough. Just imagine you're a gig worker who just finished a ride, getting ready for the next your next ride, and you find out that you're out of the platform with none to very little information that usually reads something like this, and I quote, you violated terms and conditions, close the quote. I think about warehouse workers who's penalized by productivity algorithms that doesn't account for safety checks of machines malfunctions. The CPPA has critical mandate to address this risk of ADMT, automated decision-making technology. The workers' livelihoods, careers, and well-being are on the line. We urge you to enact regulations that explicitly include these core protections for workers and gig workers. California has the power to lead by example. Don't let corporate interests override fundamental worker rights and fairness for all working class people in California. Thank you.
Thank you very much. Could we hear a comment, two comments from Zoom, please?
Yes. Edwin Lombard, I'm going to unmute you at this time. You'll have 3 minutes to make your comment. Please begin as soon as you're ready.
Thank you. Good afternoon, Chairman Urban and board members. My name is Edwin Lombard. For a few years now, the organizations that I represent, which include, but are not limited to, the California African American Chamber of Commerce, a number of local Black chambers of commerce, the Black Business Association, community-based organizations, and faith-based organizations throughout the state of California, have been concerned about the economic impact of the CPPA regulations on small and diverse businesses in California. Today, in our humble opinion, we believe that the recent changes to the CPPA draft regulations are a reasonable middle ground consistent with the balance sought by Prop 24. In particular, we support the following: the new definition of automated decision-making technology, ADMT, removal of behavior advertising from ADMT and risk assessment, and deletion of artificial intelligence from the CPPA regulations. As to the compliance issue, we respectfully request that CPPA adopt one compliance date for all CPPA regulations: automated decision-making technology, cybersecurity audits, and risk assessments regulations. California continues to have a budget deficit, and the volatile federal economic policies that are likely to exacerbate the ability of small and diverse businesses to operate in California. CPPA can help alleviate economic challenges for small and diverse businesses by adopting one compliance date for all CPPA regulations. I thank you and I appreciate the great work that you have done, and we will continue to work with CPPA as we go forward.
Thank you, Mr. Lombard.
Vincent Cortez, I'm going to unmute you at this time. You'll have 3 minutes. Go ahead and begin when you're ready.
Good afternoon, everyone. My name is Vincent Cortese, and I'm here on behalf of the Center for AI and Digital Policy. We are a nonprofit research and education organization headquartered in Washington, D.C., with an affiliate here in California. We commend the CPPA for your continued leadership in advancing strong privacy protections in California. However, we believe a few key provisions are missing from current draft, such as recommending the following. First, we encourage the CPPA to adopt strong data minimization requirements for ADMT. Businesses should collect only the data that is necessary for a specific lawful purpose. For example, health records or social media activity should not be used in employment or credit decisions unless directly relevant. This aligns with the CPPA's core privacy principles and international best practices. Second, we recommend establishing standardized incident reporting mechanisms for ADMT. Issues like biased loan decisions or flawed health predictions may seem isolated, but can quickly add up to systemic harm. Requiring consistent reporting will help the CPPA detect patterns, promote accountability, and prevent broader violations of privacy and civil rights. Third, we urge the CPPA to require independent socio-technical expert evaluations as part of external stakeholder assessments under Section 7151. AI systems are not just technical tools. They operate within complex social, organizational, and legal contexts. The NIST AI Risk Management Framework makes clear that diverse and multidisciplinary evaluations are critical to identifying risks like discrimination and bias that technical reviews alone may overlook. These evaluations should be conducted by experts with no financial ties to the business and include strong disclosure and documentation requirements to ensure transparency. Finally, we urge the agency to reinstate transparency requirements in Section 7152, subsection A, paragraph 2, and opt-out requirements in Section 7221. These provisions are essential for ensuring transparency and giving consumers the right to opt out of automated decisions that affect their lives. A human appeal process alone is not enough. People deserve both clarity and choice. By adopting these recommendations, the CPPA can strengthen California's role as a leader in responsible AI governance and help ensure AI systems are fair, transparent, and protective of individual rights. Thank you.
Thank you very much. Let's move back to in-person comments, please. Please go ahead when you're ready.
Hi, my name is Alejandra. Soy una trabajadora independiente para aplicaciones de viajes compartidos. Me gustaría hablar en nombre de miles de conductores aquí en California. A menudo somos penalizados, la mayoría de las veces no tenemos idea de por qué. No somos desactivados, estas decisiones están siendo tomadas por tecnologías automatizadas con poca o ninguna decisión humana. Este tipo de situaciones afecta a muchas personas de clase trabajadora. Estamos como, ¿cómo vamos a hacer para pagar la renta? ¿Cómo vamos a pagar? ¿Cómo vamos a llegar con nuestras familias y decir que no tenemos trabajo por desactivaciones? Nuestras familias estamos susceptibles a esta situación. Las corporaciones como los que trabajamos recompilan muchos datos sobre mí. No debería de tener derecho a saber qué tipo de datos se recopilan y cómo se están utilizando mis datos. La tecnología de datos automatizada se está utilizando para imprimir a los trabajadores. Hemos visto y documentado unas cuantas veces de donde los conductores son pagados de manera diferente por los mismos viajes. No tenemos idea de por qué alguien recibiría un mejor pago que otro en los viajes personalizados de punto A a punto B. Les insisto, protejan la CCPA y no debilitar las regulaciones en juntas. Tienen el poder de protegernos a todos los trabajadores y consumidores, así como les pido que hagan lo correcto. Behind every driver like me, there are families and childs who depends on us, and we depend on the passenger, and we do everything possible to give yourself strength to work so that we can all give all the best, just like you here, making your best decision, not only for yourself, but for the future, for all the families.
Muchas gracias por su comentario.
I'm going to translate the first part. Is that okay?
Sure, please go ahead.
Good morning. My name's Alejandra Aguilar, and I'm a gig worker. I'd like to speak on behalf of thousands of drivers here in California. Often we're penalized. Most of the time we have no idea why. For example, when we get disactivated. These decisions are being taken by automated technology with little to no human decision. And these kinds of situations affect many working class people. These decisions made by technology have a real and cruel impact. How are we going to pay rent? How are we going to come back home and tell our families we've been fired without even a clear answer as to why it happened? Corporations like the one I work for collect a lot of data on me, and I should have the right to know what kinds of data and how it's being used. Automated data technology is being used to squeeze workers, as we have seen and documented a few times, in which drivers get paid differently for the exact same rides. We have no idea why someone would get paid more than someone else for the same trip if both people are being transported from point A to point B. Today, I urge you to protect the CCPA and not weaken its regulations. This board has the power to protect us all. Therefore, I ask you to do the right thing. Thank you.
Thank you very much.
Good afternoon or good morning. I don't know what time it is. My name is Samantha Gordon. I'm with Tech Equity. I also want to echo the thanks to the staff and to the agency leadership and the board. There has been a lot of hard and diligent work we can see going into these regulations. You will hear, however, in my comments, our frustration with where the regulations have landed. As previous commenters have said, there is a large number of labor, consumer, tech policy experts, advocates who have all been weighing in really diligently on these regulations, showing up here at this board, painstakingly reviewing these comments and regulations. I would also note, I know there's been questions about whether or not folks are interpreting them correctly, and so I just also want to lift up the level of PhDs that have been reviewing these regulations on our behalf, not to mention lawyers and people with lived experience who you hear here in this room. So despite all of this work, we've seen that many of the recommendations we've made, almost all of them, have been ignored as these successive rounds of lobbying have happened in front of this board, and we've seen the regulations get weaker and weaker. We're deeply concerned about two things in particular, but many things overall. The extremely narrow definition of ADMTs. So I'm going to read from here so I don't miss anything. Under this definition, as you all know, a company could decide that their system does not substantially replace human decisions and is not covered by these regulations. For example, a national health insurer reportedly implemented an ADMT that used personal data to analyze insurance claims. And under that system, doctors are supposed to review them before making the final decision. And that decision would deny or approve payment for patient care. So under this definition of ADMTs, we assume companies would not consider this use as covered. Right? A doctor's reviewing it. It's not substantially replacing. However, an independent investigation found that these doctors only spent an average of 1.2 seconds to review each health insurance claim. Under the current regs, businesses will point to human involvement to exempt them from providing patients proper notice and explanation, even when the business's use of their personal data creates significant risk to the consumer of an inaccurate or harmful decision. And as the CPPA themselves have acknowledged, this choice to weaken the definitions allows almost all companies to avoid accountability, exempting a reportedly 90% of entities covered by this agency. And what's more, even in the slim number of cases in which these draft regulations would apply, affected individuals who had been denied a job, an apartment, or healthcare would likely not know about it because of the weak language around use notice. So we heard today, that there are questions about whether or not the concerns are overblown or maybe that, folks aren't interpreting these regulations. Unfortunately, the concerns are not hypothetical. They're based on evidence of what companies do with these types of loopholes, both in the implementation of regulations surrounding ADS and other jurisdictions, but additionally with the interpretations of guidelines when it comes to protecting workers' and consumers' rights. These are not ill-informed or naive concerns. They are based on collectively decades of experience with why companies fight for these changes in the first place. You will hear companies today tell you these are balanced, these are great, and you will hear workers and consumers tell you we do not have enough protections based on the regulations as written. So while the privacy agency is unique in this rulemaking, the playbook we've seen operate here is not unique. We work on these issues in states across the country. This is a playbook that has been used across the country to weaken definitions.
That is your time.
And add exemptions. Thank you.
Thank you very much. Ms. Carwell, I just want to check in on the number.
We have 10 commenters online currently.
Okay, thank you. With your patience requested, thank you so much. Please, let's take a couple more comments on Zoom. Are there folks out at the door here, or are the four folks in line? Okay, so we have 4 here. So with your indulgence, we'll take a couple of comments on Zoom, and we'll sort of go back and forth so that we have an equitable spread of comments. Thank you.
Peter, I'm going to unmute you at this time. You'll have 3 minutes. Go ahead and begin when you're ready.
Good afternoon. My name is Peter Lerome Munoz with the Silicon Valley Leadership Group, part of a statewide coalition of business association and chambers of commerce wishing to express our opposition to the proposed rulemaking package. First, we are extremely disappointed that the staff report was made available on the website with very short notice. Stakeholders have had little time to thoroughly review and assess the agency responses to our comments. Unfortunately, this seems to be a troubling pattern where the process is rushed and ignores the pleas of California's community of small and medium-sized businesses. The agency's approach sends a clear message that the voices of California's business community are not being taken seriously. Our concerns remain and are focused on the high cost and complex nature of the proposed regulations, the agency's focus on punitive enforcement over business education and compliance assistance, in addition to the agency's straying beyond its original scope and intent. In addition to the high upfront costs and labor impacts of for California businesses, we urge you to take a closer look at the financial burdens on small businesses. Providing small businesses with information on the true cost of compliance will better prepare them to allocate the resources required by the proposed regulations. We respectfully ask that the agency halt the rulemaking process and work directly with the governor and the legislature to assess the need for a program and the scope and the cost of the program to the state, including the true cost to the general fund and to consumers and businesses. Thank you.
Thank you very much.
Boykin, Robert Boykin, I'm going to unmute you at this time. You'll have 3 minutes. Go ahead and begin when you're ready.
Hi, good afternoon, CPPA board members. My name is Robert Boykin on behalf of TechNet. We represent more than 100 companies in the technology and innovation industry. We represent companies across the spectrum of the innovation economy, from those that develop cutting-edge technology to the many companies that deploy it for consumer users or utilize automated decision-making technology in some capacity to improve their business operations. I would like to thank the board for your efforts today and attention to our concerns in past versions. However, I would like to also express our widespread disappointment regarding agency's failure to meaningfully update the draft regulations based on the most recent comment period. While we were pleased with the changes to these regulations in previous rounds of comments, these proposed rules remain overly broad, go beyond the agency's mandate, and would burden California's innovation economy. The agency's unwillingness to make meaningful changes in response to detailed feedback from stakeholders shows an apparent disregard for what Governor Newsom put in his letter to the board. And I quote, "Enacting these regulations could create significant unintended consequences and impose substantial costs that threaten California's enduring dominance in technology innovation." Some of the many unaddressed issues in these regulations include overly broad definitions that sweep in everyday business tools, including any tools defined as profiling used to track business workplace behavior. The definition of significant decision would still include software making routine workplace decisions related to work allocations. The definition of financial and lending services would sweep in tools used for non-credit purposes, potentially including most forms of digital payment activity. The list of requirements for these notices about ADMTs still create excessive burdens based on subjective language without any clear benefit to consumers. It is also concerning that the agency appears to be using flawed algebra in their analysis by overstating the benefit to the state. In the final statement of reasons, the agency lowers the cost of cybersecurity audits by 30% because it recognizes many companies already comply with duplicative cybersecurity frameworks. Instead of also reducing the benefits, it leaves them untouched and increases them. If it's true that companies are already complying, it does not make sense to only discount one side of the ledger and downplay the compliance cost to companies while maintaining the benefits to the state. Overall, the required audits and risk assessments are overly prescriptive and too frequent, forcing companies into a detailed annual California-specific box-checking exercise that detracts from the actual maintenance and defense of consumer privacy. Lastly, we continue to urge a 24-month timeline to come into compliance for any provisions other than its existing date, ensuring companies can comply. We believe that agencies should focus on the primary obligations as a privacy agency rather than broadly attempting to regulate the use of automated technology and AI. Thank you for your time today.
Thank you. Let's take a couple of comments in person now. When you're ready, thank you very much.
Good afternoon. Hello? Hello, can you hear me? Okay, perfect. Good afternoon. My name is Ivan Fernandez. I'm with the California Federation of Labor Unions, representing 2.1 million workers, here to express our disappointment towards the weakening of the proposed regulations. We have engaged with the agency throughout the rulemaking process, yet we stand here today with a much weaker set of proposed regulations that will ultimately fall short in protecting everyday Californians. This is especially concerning considering the increased use, availability, and affordability of automated decision-making technologies and its profound impact on consumers and workers. As many are already aware, these tools have the capacity to completely outsource human decision-making with little to no oversight and can be used to impact the lives and livelihoods of workers. With individual and worker data, ADMTs can be used to conduct a wide array of tasks, such as setting worker schedule, to firing and discipline, and even in certain circumstances, attempting to predict a person's future behavior. Essentially, as we just heard, a worker's data can be used immediately against them. Without meaningful regulation, these tools will run rampant across all industries. It is our assessment that the current proposed regulations do not provide the protections that consumers and workers clearly deserve under the CCPA, and that the law itself clearly intended. Specifically, as detailed in our coalition letter, we believe that definitional changes have left large swaths of workers and consumers unprotected, that the revised notice and data access regime will not work for workers or consumers, and that the revised ADMT opt-out provisions have become even more inaccessible to workers. And lastly, that the risk assessments have become weak tools for identifying ADMT harms. Lax guardrails will exacerbate issues surrounding worker data and privacy. While these technologies continue to emerge, workers and consumers deserve proper autonomy, transparency, and disclosure. In sum, we strongly urge agency staff and board members to reconsider the current trajectory of the proposed regulations. Thank you.
Thank you very much.
Good afternoon again, Board Chair and members. Danny Kando-Kaiser. I'm speaking on behalf of the Electronic Frontier Foundation. Want to echo what others have said and acknowledge the hard work of agency leadership, staff, and board members on these regulations over the past 2 years and for the time they've spent speaking with us advocates on these complex issues. That said, we echo the deep disappointment of our fellow consumer advocates and our friends in the labor advocacy community over the direction these regulations have taken, and that despite several meetings and communications with our coalition of 70 labor and civil society groups advocating for the rights of workers and consumers, none of our feedback has been reflected in the draft seen before us today. This is a missed opportunity for California to lead on these issues and follow its mandate to protect the privacy rights of the people of this state. We strongly urge Executive Director Kemp, agency staff, and board members to reconsider the current trajectory of the proposed regulations, and we thank you for this opportunity.
Thank you very much. Let's take 2 comments from Zoom.
Gilbert Laura, I'm going to unmute you at this time. You'll have 3 minutes. Go ahead and begin when you're ready.
Good afternoon, board members. My name is Gilbert Lara on behalf of Biocom California, and we represent biotechnology, pharmaceutical, medical device, genomics, and diagnostic companies, research universities, and clinical research organizations. We appreciate the phased implementation of cybersecurity audits. However, these regulations create unnecessary burdens for our federally regulated industry. Life sciences already comply with FDA oversight of over hundreds of AI and machine learning medical devices and extensive clinical trial regulations. Adding state requirements duplicates existing protections without enhancing privacy or safety. California has historically respected federal oversight of life sciences, and we respectfully urge you to consider future amendments recognizing FDA and HIPAA compliance as satisfying state requirements, allowing us to focus on developing life-saving technologies rather than redundant paperwork. We stand ready to work with you to achieve our shared goals, protecting patient privacy, while ensuring California remains the leader in life-saving medical innovation. Thank you.
Thank you very much.
Jason Lane, I'm going to unmute you at this time. You'll have 3 minutes. Begin when you're ready. Jason Lane, are you there?
Yes, apologies. Thank you, members of the board. Jason Lane, California Bankers Association. Thank you for the opportunity to speak. We appreciate the agency's effort to refine the proposed rules over time. Unfortunately, the current draft still fails to address several critical concerns raised by the banking industry. First, the cybersecurity audit rules remain overly rigid and duplicative of longstanding federal bank oversight. They ignore tailored risk-based frameworks that banks already follow under the Office of the Comptroller of the Currency, the Federal Financial Institutions Examination Council supervision, potentially weakening, not strengthening security measures by misallocating resources. The automated decision-making rules, importantly here, eliminate vital fraud detection exemptions and sweep in routine transaction monitoring. This could create real-world vulnerabilities by forcing institutions to reveal or justify systems that protect consumers from fraud. The agency's response to our concerns in our June comment letter is that the agency modified the definition of ADMT to focus on higher risk use of ADMT, which is a use without any human involvement. Unfortunately, that answer doesn't really take into account that many of the essential fraud and security systems that are used by financial institutions operate without human involvement by design in order to identify and block threats in real time. And these tools are very critical to protecting consumers, maintaining trust in the financial system. For rulemaking and a statute that proposes to enhance consumer protections, this seems like a miss to us. So we urge the agency to reconsider these areas to provide meaningful explicit exemptions or alignment for federally regulated banks. Thank you.
Thank you very much. Let's take 2 comments from the room in person.
Good afternoon. I'm Ariel Hernandez, Regulatory Policy Specialist with the California Nurses Association, a labor union representing over 100,000 registered nurses across the state. As CNA has stated at previous board meetings and in our written comments, we are deeply disappointed in the board's choice to set aside the recommendations from unions who have deeply engaged with this process in a coalition of 70 labor and civil society groups, representing hundreds of thousands of workers and consumers to maintain the broad scope and robust protections in the ADMT regulations. California is the only jurisdiction in the country where workers have a right to privacy in the workplace. Voters gave the CPPA a legal mandate to issue regulations to protect consumer privacy, including worker privacy from harmful collection and use of their private data. The revised ADMT regulations fail this mandate. Significantly scaled back in scope, the revised regulatory proposal does not ensure that consumers and workers have the ability to understand when and how their private data is being collected or used, and importantly, to address any harmful collection or use of their data. We are deeply concerned about the changes to the definition of ADMTs to include only those that substantially replace human decision-making. This change will allow employers and other corporations to easily opt themselves out from the rules reach by simply claiming that an algorithmic tool is only advisory to human decision-making. Registered nurses use automated decision-making technology every day in their workplaces. ADMT plays a significant role in setting staffing levels, scheduling, and crucial patient care decisions. Almost all the ADMT used by nurses avoids FDA regulation as a medical device through developer and deployer claims that it is merely advisory to human decision makers. The reality is very different. Nurses are pressured to comply with ADMT recommendations by management, by time, and by design of the technology. The lack of transparency in healthcare algorithmic systems puts patients at risk both in the short and long term. In the short term, inappropriate recommendations from an ADMT can result in inappropriate and harmful patient care. Over time, as employers require or functionally require healthcare workers to rely on algorithms instead of their own professional judgment, ADMTs may degrade the skill of the very healthcare professionals who are responsible for identifying errors in the outputs. Algorithmic technologies are making life and death decisions on healthcare and working conditions. They are impacting the lives and livelihood of millions of patients and workers every day. Patients and workers are in dire need of the guide rails in the original draft of these regulations. Therefore, we strongly urge the agency and the board to change course, follow the mandate of voters, and adopt regulations that meaningfully protect worker and patient privacy. Thank you.
Thank you very much.
Good afternoon. My name is John Davison. I'm the Director of Litigation for the Electronic Privacy Information Center, or EPIC. We're a public interest research center established in 1994 to safeguard privacy, freedom of expression, and democratic values. EPIC has long supported the realization of robust protections for Californians against harmful commercial surveillance practices, We've been a consistent voice in support of the agency's efforts to implement and make good on the promise of the CCPA. We followed your work closely at each step. We've offered expertise and recommendations at every opportunity. And by and large, we've been impressed and very grateful for the results of the CPPA's regulatory and enforcement work. We know how long and how hard the staff and the board have worked, and we thank you for that. And as this morning's conversation underscored, the agency is right to view itself as a national and international leader on data protection, especially with respect to the forthcoming drop system. So when I say the following, it comes from a place of sincere concern and shared interest in ensuring that the board and the agency are as successful as possible at their mission. The board is dropping the ball today. It's dropping the ball on automated decision-making systems, it's dropping the ball on cybersecurity, and it's dropping the ball on risk assessments. The current proposal before you represents a significant retreat and a missed opportunity to realize the type of protections against the encroach of commercial surveillance that Californians voted for. And that retreat comes at exactly the wrong time, just as our federal government is in the throes of a deregulatory rampage and a spiraling AI frenzy driven largely by the forces of big tech. I won't try to cover our comments in detail, those are already in the record before you. But as we pointed out there, the proposed rules exhibit critical self-inflicted wounds. The narrow definition of ADMT is dangerously under-inclusive. Central transparency and accountability mechanisms have been omitted. The cybersecurity obligations have been watered down, and the risk assessment obligations of businesses have been hollowed out in troubling ways. Now, the last item is of special concern to EPIC. At the beginning of this rulemaking process, we set out to produce a public report that would have built on the agency's previously robust risk assessment framework to recommend consumer-centric best practices for businesses. Unfortunately, as a result of the weakening of those rules, we were forced to devote a significant portion of that report, which was published last month, to explaining how the CPPA's proposed rules come up short and fail to fulfill the statutory goal of restricting or prohibiting unduly risky data practices. Over the past few years, the agency has defended its role as a leader on data protection against potential federal preemption, and that's certainly understandable. But this is precisely the moment for the board to make good on the leadership role that it occupies, and to reject industry pressure to deliver less than what Californians deserve and less than what they voted for. This is not the time for half measures on AI and data protection, so we urge you not to adopt the regulations as drafted, and instead to turn back to the far stronger model that the agency previously put forward. Thank you.
Thank you very much. Shall we take 2 comments from Zoom? Thank you.
Lou Katz, I'm going to unmute you at this time. You'll have 3 minutes. Begin when you're ready.
Thank you. Good afternoon. My name is Lou Katz. I'm a commissioner on the City of Oakland's Privacy Advisory Commission and a member of Oakland Privacy. I'm distressed by the proposed changes of the regulations put forward by this agency. The changes appear to be a handbook for how to evade, circumvent, or ignore the protections originally enacted for working people in the state. Changes to the definitions of the regulations are fashioned so as to remove large numbers of consumers and workers from the protections offered by the regulations. Revised notice on data access are structured so as to make it almost impossible in reality to use the provisions of the regulations. Self-certification of compliance with imprecise and vague requirements are a beacon for loophole creation and legal compliance with the opposite actual effect. How can one find out if a procedure has been used to their disadvantage if one cannot in reality find out if any procedure has been used, no less which one? When humans make decisions, one may be able to confront the human and question the decision. Who do you confront when a computer program makes a decision? The fact that humans decided to acquire a particular program and to use it in a particular fashion does not seem to imply any responsibility on their part, nor that they are subject to any consequences related to the use of the program. The actual working of these programs are usually surrounded by impenetrable legal layers of trade secret and non-disclosure. Built-in bias cannot be discovered or demonstrated. The actual working of these programs are usually In all, the current changes seem designed to shield businesses from accountability and consequences, and to make it nearly impossible for workers and consumers to even exercise what few rights and protections they have left. Thank you.
Thank you very much. Thank you for your patience. Please go ahead. We'll move to one more comment in the room.
Good morning. My name is Neil Martin, and I'm Tech Justice Coordinator at Working Partnerships USA. We are a CBO based in San Jose, and we work to address the root causes of inequality and poverty by working a coalition to promote job quality, healthy communities, equitable growth, and vibrant democracy. I'd like to acknowledge the hard work of the agency, its staff, and its board members, and it's good to see so much time and energy going into efforts paying attention to these issues that affect all of us, and increasingly in such deep ways. But I'm here to express my concerns about the proposed changes to these regulations, which, as many have already mentioned, fail to reflect some of the recommendations we've made over time, into which a huge amount of work and expertise has gone. Allowing the private sector to self-regulate itself in some ways is not, I think, in the public interest. So to allow employers to decide for themselves whether or not an automated decision replaces or substantively replaces human decisions, I think won't really work. Some high-road employers may make the right decisions and be honest, but many, of course, won't. And at the end of the day, without guardrails, we think most companies are going to prioritize, interests that are in conflict with workers in their communities when they're making those decisions. Employees and all members of society should be able to know what data is being collected on them, why, how, and how it's being used. And we don't think the draft regulations currently reflect the intent of voters or the goals of the CCPA, which are to ensure that consumers and workers have the information necessary to, quote, exercise meaningful control of businesses' use of their data and have, quote, meaningful options, unquote, over how that data is collected, used, and disclosed. In emergency digital technologies like ADMT and data collection are already reshaping the workplaces across the board. And so I think it's relevant to ask ourselves the question here, given that AI is influencing, a lot of the sectors of work that we've heard from today here in the room, but is increasingly affecting, public sector workers, government workers, private sector workers. And if we believe the tech companies, it's going to be replacing and shaping, advanced professional work as well. Would we be okay with an automated decision process or computation process deciding how much we make, how much, whether or not we're fired or promoted, what we have to do at work, and would we be okay with that happening without even knowing when it's happening, right? So I think it's the kind of question we should all start to ask ourselves. And lastly, I just think California should be a model for regulations. And so we should support the development of responsible digital technology. And I firmly believe that basic guardrails on AI and digital tech is not going to stifle innovation. I think that argument is that we're hearing so much. We don't really have evidence to believe that that's true. I think we're seeing quite the
Thank you. That is your time.
Thank you. Let's move to Zoom comments.
Again, this is for agenda number 5, and if you're joining us virtually and like to make a comment, please raise your hand using the raised hand feature or by pressing *9 if you're joining us by phone. Lucy Chinskin, if you want to go ahead and speak, I will unmute you at this time. You'll have 3 minutes.
Thank you. Good afternoon. Lucy Chinkezian at the Civil Justice Association of California. Thank you for the opportunity to provide public comment today. Our membership base consists of businesses and associations from a broad cross-section of California's industries. Our members continue to have serious concerns with the draft rulemaking. While we appreciate that the agency has taken into consideration some of our previous concerns, our most recent public comments submitted in June have not been addressed. The latest draft regulations continue to include vague and overly broad definitions of artificial intelligence and automated decision-making technology, which risks capturing a wide array of low-risk, beneficial business tools. Moreover, this rulemaking threatens to conflict with ongoing efforts in the legislature and the governor's office to craft a unified and innovation-forward AI policy. California's regulatory landscape must be coherent and coordinated, not fractured and duplicative. CJAC respectfully urges the agency to delay the submission of these regulations. As currently drafted, they could have serious, lasting consequences for innovation, employment, and economic growth across the state. Thank you.
Thank you.
Mark Wingardner, I'm going to unmute you at this time. You'll have 3 minutes.
Thank you. Good afternoon. Thank you for the diligent work that this board and its staff perform. My name is Mark Weingartner, and I serve as the second National Vice President of the International Cinematographers Guild, Local 600 of the IATSE. Our members are the camera crews and publicists working in motion pictures and television across the country, a great many of us in California. The members of my local and those of our sister locals across media and entertainment are deeply concerned about the impact that the adoption of artificial intelligence, automated decision-making technologies, and other data-driven technologies will have on our workplaces, not just the way we work, but as importantly, the way we are managed, categorized, and scrutinized. By covering worker data in the CCPA and the promulgation of regulations, California has an historic opportunity to lead the U.S. in establishing workers as key stakeholders in decisions about how best to govern artificial intelligence, and particularly to give workers agency in controlling the collection and use of our personal data. Alas, our state is on the cusp of missing that opportunity with the weakness of the current iteration of the proposed regulations, favoring the interests of business and the tech sector over the protection of workers and consumers. The current proposed regulations do not provide the protections that consumers and workers deserve under the CCPA and the law itself clearly intended. In particular, definitional changes leave large swaths of workers and consumers unprotected by the proposed regs. The revised notice and data access regime will not work for workers. The revised ADMT opt-out provisions have become even more inaccessible to workers. The risk assessment requirements have become weak tools for identifying and addressing ADMT harms. These revised regulations fail to meet the spirit and substance of the rulemaking charge that was given to the CPPA by voters, particularly in the area of automated decision-making technology. The emergence of data-driven tech represents one of the most important issues that will shape the future of work in California for decades, affecting worker privacy, wages and working conditions, race and gender equity, right to organize, and autonomy and dignity. California's workers deserve the broad protections, transparency and disclosure, and agency over data-driven technologies that these regulations could have delivered. We strongly urge Executive Director Kemp, agency staff, and board members to reconsider the weakening of the proposed regulations and revert back to the intent of California's privacy law and that of the state's voters. Thank you for providing this opportunity to speak.
Thank you.
Robert Singleton, I'm going to unmute you at this time. You'll have 3 minutes. Go ahead and begin when you're ready.
Good afternoon, Chair Urban, Director Kemp, and board members. My name is Robert Singleton, and I serve as the Senior Director of Policy and Public Affairs at Chamber of Progress, a tech industry association supporting public policies to build a more inclusive society in which all people benefit from technological advancements. I'm here today to offer comments on the not substantially different proposed regulations regarding automated decision-making technology and cybersecurity audits. First off, I'd like to thank the board and staff for all of their work and for the amendments to the draft regs that have already been made. In particular, the removal of mention of artificial intelligence that had been included in the original regulations, which was out of scope of the agency's directive of dealing with consumer privacy. We also appreciate the removal of behavioral advertising provisions and the revised definitions of ADMT. However, we still remain concerned with regards to some of the definitions and requirements within the regulations, many of which would incur substantial costs to small businesses throughout California. Additionally, it is further concerning that the board is considering taking formal action at this meeting, given the limited notice that was given. It's only been 3 months and Governor Newsom sent his April 4th letter warning the agency of taking on too much with regards to AI, and his working group hadn't even. So while we appreciate the agency having taken his call to narrow the scope of these regulations seriously, we still do not feel that enough time has been given for stakeholders to adequately engage with the material and the changes, especially when considering the concurrent work of the legislature, which only just went into recess last week after the passage of many bills dealing with similar subject matter. Specifically, the modified text language on certificate decision is still deeply problematic. It applies to decisions that result in provision or denial of financial lending services, housing, education, enrollment opportunities, as well as employment and independent contracting opportunities. Notably, it further includes allocation or assignment of work for employees. This broad wording implicates a large swath of the platform economy. California-based platforms like Uber, DoorDash, Instacart use algorithmic tools to assign tasks in their normal course of business. By burdening these platforms, the agency is not merely regulating tech companies, but it is undermining the drivers, restaurateurs, grocers, and consumers that depend on these services daily. This burden is perhaps most acutely felt for homebound and disabled Californians who may lose access to delivery services for groceries and prepared meals as businesses struggle to comply with these regulations. Furthermore, the AD&T training requirements haven't been removed from the regulations before you. The training of AD&T systems is a complex and exceedingly technical process, oftentimes involving the ingestion and processing of a wide variety and high volume of data tokens. The regulation of such a nuanced and yet essential process is something that should be reserved for the legislature, especially when considering the economic impact that the regulating of training data might impose on the state's growing AI industry and the California economy broadly. Even with the revised text, the AD&T regulations continue to impose requirements on basic tools used in routine business operations. This overreach will stifle innovation and create costly compliance burdens, especially for small businesses with limited resources to comply with complex regulations. The result is a chilling effect of technological advancement that will disproportionately harm California businesses and the consumers they serve. In conclusion, we share Governor Newsom's concern that the CPPA's regulatory undertakings could create significant unintended consequences and impose substantial costs that threaten California's enduring dominance of technological innovation. CPPA should focus its core mission and not yet adopt proposed regulations and instead give stakeholders more time to engage in the material. Thank you.
Thank you.
Thank you.
Minsu Longaru, go ahead and speak. You'll have 3 minutes. Begin when you're ready.
Thank you and good afternoon. I'm Minsu Longaru, Senior Staff Attorney, PowerSwitch Action. We're a national network of 21 grassroots affiliates, including 7 right here in the state of California. Today, we're here with a coalition of 70 California labor and civil society groups. We join in the June 2nd comments submitted by Dr. Annetta Bernhardt on behalf of the coalition. Today, as grassroots organizations with our ears to the ground, we are here to express our deep disappointment at the substantial weakening of the proposed regulations. Today, we convey the urgent need for this board to enact stronger and more meaningful AD&T safeguards. Today, corporations are using automated decision-making systems to determine whether to hire, fire, or suspend workers. Often, workers have no way of knowing if this is happening or what criteria are being used. A recent study by the Action Center for Race in the Economy surveyed more than 700 app-based drivers across the country who were subjected to automated decision-making. It found that nearly 2/3 of drivers reported that they had been given no meaningful explanation of the reason for their firing or suspension. Today, corporations are also using automated decision-making to determine workers' schedules, tasks, and pay. This causes workers' pay to fluctuate in ways that are difficult for them to predict and understand. A recent study by PowerSwitch Action and Gig Workers Rising surveyed more than 2,500 app-based drivers across the country who were subjected to automated wage setting. It found that an overwhelming majority of drivers, 78%, reported that driving feels like gambling. Nearly 6 in 10 drivers also reported experiencing at least one serious financial hardship in the last year, and nearly 3/4 of those drivers reported that the serious hardship was because they earned less on the app than they expected. The harms that corporations' use of AD&T are causing working Californians today are clear. The question for this board is what will happen tomorrow and the next day and the next. The changes in the board's latest draft regulations contain poison pills that are too much for California workers and consumers to swallow. Will this board take the necessary steps to advance safeguards that protect Californians and enact meaningful checks on concentrated power in the tech industry? We urge this board to adopt the recommendations and principles set forth in our January 9th, 2025 and February 26, 2024 coalition letters. Thank you.
Thank you. Ronak Delami, I'm going to unmute you at this time. You'll have 3 minutes. Go ahead and begin when you're ready.
Thank you. Ronak Delami with Cal Chamber. We could not disagree more with the agency comments today. A long process does not inherently make it a prudent or inclusive one. It was not until April 2025 that the agency gave us any reason to hope progress could be made, with the first important but minimal changes. At the time, we expressed our appreciation, but we were also careful to stress that the agency still had a long ways to go. We were all severely disappointed when less than 48 hours ago, this agency decided to ignore the 400-page summary of public comments. The governor, as well as nearly 24 legislators, are not making a single change since the agency last met. Instead, the agency cited at least 620 times that it disagrees with a comment from the public, providing largely cursory responses. Even the agency's own proposal explicitly states its intent to adopt the May 9th version, nearly a month before the comment period closed on June 2nd. It's hard not to conclude that the comments were not given any due consideration and that this outcome was predetermined. What's most confusing is why this vote to proceed to OAL is happening today when you have almost 4 more months before submission needs to be finalized. And even then, you could resume the process where you left off, doing things like a sorely needed new SORIA. I hope someone will answer what the rush is, because these actions fly in the face of transparency and good government. We implore you in the strongest terms possible to please pause and narrow the ADMT provisions to fully exclude training, regulate only fully automated decisions, and remove pre-use notice and appeal rights, to delete the new sensitive locations concept absent statutory authority, and provide realistic compliance timeframes that address the regulation's practical difficulties, which we believe warrants 24 months or at least until January 1st, 2027 for all provisions. We also ask that you remove explainability requirements that exceed your mandate, raise assessment thresholds, and focus on activities posing significant privacy risk as mandated, ensure cyber audits are risk-based and interoperable and align thresholds with statute, guarantee legal privilege and confidentiality for assessments and audits, and address vagueness and overbreadth issues, among other things outlined in our letter. As we've said so many times before, we can't afford to get this policy wrong, which brings me to the Form 399. The agency's economic estimates have fluctuated wildly, and the FSOR presents little evidence to support accuracy in these new numbers, in some areas making changes based on what appears to be theory and not applied to methodology that we can discern. While we suspect that the number is much higher, even the agency estimates that at least 98,000 Californians will lose their jobs in the next 3 years. California just got tagged as having the nation's highest unemployment rate. This should horrify us all, or at least be taken seriously by not voting knowingly put out 100,000 more Californians out of work. Additionally, you estimate that small businesses would face up to $38,000 in initial compliance costs and an additional $16,000 annually thereafter. Amidst of such economic uncertainty, this is not the time to saddle California small businesses with such unabsorbable and unsustainable costs. It shouldn't even be a debate. Public policy is about balance, and this draft fails that test. A fix-it-later approach when you've gone too far doesn't unwind the harm you do in the meantime. This is the same talking points given by members of Congress who just voted for a bill to cut Medicaid, but said they'll immediately start to work rolling back those cuts. Please reconsider. Thank you.
Thank you. Aidan Downey, I'm going to unmute you at this time. You'll have 3 minutes. Begin when you're ready.
Good afternoon. My name is Aidan Downey, State Policy Manager for the Computer and Communications Industry Association. CCIA has engaged extensively in this process, submitting detailed comments alongside many companies that build and deploy AI tools responsibly. Unfortunately, the CPPA has not adequately examined critical concerns raised by the stakeholders. There's still fundamental problems with how these rules define critical aspects of the regulation, like automated decision tools and artificial intelligence. The consequences are not hypothetical. California lost over 90,000 tech jobs last year, an indicator that the tech capital of the world may be failing its businesses. Rushing forward with conflicting AI regulations will only deepen that trend. We're not asking the agency to abandon its hard, diligent work, but to slow down and get it right. These rules still contain vague standards like relevant information, inhuman review requirements, overly broad definitions of ADMT, and duplicative risk assessment mandates. They discourage the use of privacy-preserving technologies and create new liabilities without clear consumer benefit. We respectfully urge the agency to delay submission of these rules. As drafted, they're not ready, and if finalized prematurely, they may have serious, lasting consequences for California's innovation economy. Thank you.
Madam Chair, I'm not seeing any additional hands raised at this time.
Thank you very much. Thank you to the last commentator as well. I would like to, in light of the robust discussion today and continued excellently helpful participation in public comment, I would like to request a motion to approve and adopt the regulations titled Discussion and Possible Action on Proposed Regulations Regarding, oh, sorry, I'm going to start over. I'm not having a good day. To approve and adopt the regulations regarding automated decision-making technology, risk assessments, cybersecurity audits, insurance, and updates to existing regulations as modified, and direct staff to take all steps necessary to complete the rulemaking process, including filing the final rulemaking package with the Office of Administrative Law, the amendment of any documents with the rulemaking package other than the text of the rules as necessary to ensure clarity, accuracy, and compliance with the Administrative Procedures Act, and authorizing the executive director to make non-substantive changes to the proposed regulations and to further authorize the staff to withdraw the rulemaking file in whole or in part from consideration by the Office of Administrative Law at any time if, in their opinion, the legal risks associated with disapproval of these regulations warrant further consideration by the board. May I have such a motion?
So moved.
Thank you very much, Mr. McTaggart. I have a motion. Do I have a second?
Second.
Thank you. I have a motion from Mr. McTaggart and a second from Mr. Worth. Ms. Carwile, would you please conduct the vote?
Yes, ma'am. Board Member Labert.
Aye.
Board Member McTaggart.
Aye.
Board Member Nonecki.
Aye.
Board Member Worth.
Aye.
Chair Urban.
Aye.
Madam Chair, you have 5 yeses.
Thank you very much. The motion carries 5-0. I want to again express briefly my appreciation to all the stakeholders involved, to the staff, to the board, and to our partners in the legislature and other agencies who've also given their feedback and commentary during this process. In light of the comments today and board members' statements as well, I do want to reiterate that regulations, one of the benefits of regulations, as well as being clear and implementing a law in a way that can be understood and adopted by the regulated community and by the public, is that they are more changeable than statutes tend to be, and that we are operating off an initiative from the voters that gave us a clear mandate and a requirement to issue these regulations. Obviously, an initiative is the most robust kind of law, and that is not easily changeable. But regulations are meant to be considered in light of developments. And I personally commit as the chair of the board, and I hope my fellow board members also commit to making sure that we are taking in information about how the regulations are operating in the field, how protective they are for Californians, how implementable they are for businesses, and should they be approved by OAL. I would like everyone to know that I appreciate all the work, that this is a moment in time. It's an important moment in time, and we need to have the regulations in place in order to move forward. But we understand that we will be taking on more information as time goes on. So thank you very much. This has been a very extended and careful effort, and I appreciate everybody's work on this issue for California. With that, I'm going to go ahead and call the closed session item, which is agenda item number 9 today, I believe. We will repair to closed session, and we will do that over lunch. The agenda item 9 includes personnel matters under Authority of Government Code, Section 11126A1, and pursuant to Government Code Section 1126E1 and 2A, the board will meet in closed session to confer and receive advice from legal counsel regarding litigation for which disclosing the names would jeopardize the agency's ability to conclude existing settlement negotiations to its advantage. So we will go into closed session now. We will not return before 1:45. So folks who are participating from the public can grab some lunch as well. Thank you very much. Everyone, and welcome back. We are returning from closed session where we discussed agenda item number 9, and we are now going to proceed with agenda item number 6. Agenda item number 6 is discussion and possible action on proposed amendments to regulations section 7601 to 7604 and adoption of regulations section 7160 to 7622, implementing the delete request and opt-out platform requirements, drop requirements, including possible adoption or modification of text. And I'm pleased that this item will be presented by our General Counsel, Mr. Phil Laird, Marina Feehan, one of our attorneys from Legal Division, and Gary Lee, our Honors Privacy Fellow. And I will turn it over to you all. Thank you very much.
Thank you, Chair Urban. So as the board may recall, at your March 2025 meeting, you all directed staff to commence the formal rulemaking process for proposed regulations related to the DROP system, the delete request and opt-out platform. Since that time, we did commence and run the full 45-day public comment period, beginning on April 25th and closing that comment period on June 10th, 2025. During that time, the agency received 19 written comments, totaling 176 pages of feedback and 1 oral comment at the hearing we hosted. Staff has reviewed and analyzed the public comments received, and we are further along in the development of the DROP system at this point. With feedback in mind and better understanding of the system's architecture, we are recommending modifications to the proposed text of the regulations, which then would require us to go out for another 15-day public comment period. So as a process reminder, in order for these regulations to become effective on January 1, 2026, which is when DROP will officially launch under law, we have to complete the rulemaking process and submit the regulations to the Office of Administrative Law for approval within the coming months. Approximately early November is sort of your last shot to have regulations approved by the end of the year. So with that said, sort of a table setting, I am actually going to turn it over now to my colleagues, Ms. Feehan and Mr. Lee, to discuss the proposed modifications to the text and the reasons behind those proposals.
Thank you, Mr. Laird. Based on staff's review of the public comments received and the developments in the architecture of the DROP system, staff has modified the proposed text to reflect these considerations. My colleague, Gary Lee, and I will summarize the modifications to the text. The modifications include 1, clarification on suppression list requirements. Suppression lists require that data brokers keep limited data about a consumer for the purpose of ensuring that they do not sell personal information about a consumer after that consumer has submitted a drop request. This change helps data brokers with compliance by adding safeguards to prevent data brokers from erroneously selling or sharing personal information when they should not. As a continuation of the suppression list requirements, another modification authorizes those suppression lists to be forwarded by data brokers to their service providers and contractors. This increases compliance with the DELETE Act. It helps ensure that downstream providers and contractors do not repopulate a data broker's database with personal information that is prohibited from being sold. I will now turn it over to my colleague, Gary Lee.
All right, thank you, Ms. Behan. The next modification adds clarification that the agency will verify that a job request comes from a California resident before a job request is submitted and passed on to data brokers. This safeguard minimizes the risk of falsified job requests. As a related modification, authorized agents will only be able to support a consumer job request after the consumer's residency has been verified. This minimizes the risk of fraud. In addition, the data standardization requirements have been modified to include more specific information about how data brokers shall compare the data in their databases with the data that the job provides. This helps with compliance by requiring data brokers to follow a standard when they assess whether they have personal information relating to consumers who have submitted a job request. This modification also increases the likelihood that a data broker finds a match for a consumer's personal information in their database and thus increases compliance. The next modification enhances consumer matching standards for when a data broker is comparing the data in their databases with the data that the job provides. In March, staff was under the impression that if a job consumer deletion list had multiple identifiers, the job would provide these sets of identifiers separately. This meant that if there was a partial match, there would need to be a threshold at which the partial match was sufficient to execute a deletion request. The functionality of the drop system has since changed, and deletion lists with multiple identifiers will be combined into one list and will require a 100% match. This change reflects the functionality of the drop system and minimizes the risk of erroneous deletions for data brokers.
1 second. Mr. Lee, is it all right if Mr. McTaggart asks a question?
Sure.
Right now? Okay, please go ahead.
I had a question about this. So you got 25 fields, right? And so, I don't know, they spell my name incorrectly, kind of, or they have one digit missing on an address, but it's me. But then when you run it through the hash, does it come up with a different number? So that therefore they're like, oh, this isn't him. I mean, how do we address that? Because you require 100% match, and I have a complicated last name. Everybody's name is spelled differently, and so I know what you were trying to get at before, and I guess it's not. So how do we think about that? Because the worst of all things is for us to hold out, hey, this is going to work, and then the data broker's like, oh, great, we're just going to have a old email address for one of his 4 email addresses, and that'll mean that that this actually doesn't work.
Yeah, that's a great question, Mr. McTaggart. It does reflect sort of the complexity of how we're trying to make the system both nimble, accurate, and kind of encourage the highest chance of a match between a data broker's records and what a consumer provides us through the state portal. In short, I would say you are correct that once you have a hash, it is of a specific sort of set of characters. And if there's any deviation, there's no way to find out that there is a close match beyond something else. But one of the strategies of how we've designed the system and how we've broken up personal identifying information into different deletion lists is there's sort of multiple occasions where you might get a match even if it doesn't work out in Venue. So to your point, one that we're contemplating at this stage would be first name, last name, zip code, and date of birth. Obviously, you're right. There's a lot of characters there where if there's an error or a slight difference based on a data broker's records, there may not be a match. At the same time, though, if you're a consumer, you're also going to give the opportunity to provide an email address, which is a separate deletion identifier. So if I'm a data broker who has both names as well as email addresses, maybe I didn't get a match on your name because I had a wrong letter or something, but if I have your email address, it'll match and that deletion request will still have to be fulfilled.
And so this is what I didn't understand. So because I think that's a good point. Let's just say I have my email address and I have 4 email addresses, right?
Yes.
Is there a separate requirement for the data broker to check each one of those email addresses by itself against a list?
Yes.
Not tied to my name or my address because I might have moved?
That's exactly right.
Okay.
Yeah. So we'll be doing that. You can enter multiple email addresses, multiple
So I might have
phone numbers.
4 addresses, an old one, whatever, and they have to check each one against a list. It's not if they're all together linked to the same one that
Not all
works.
It's not all 45 items that possibly could be collected that
That's
have to
correct.
be combined, as I understood Mr. McTaggart's initial question, because there are multiple paths towards deletion requirement.
Yeah, that's correct. And certain, and that's where we've recognized certain identifiers on their own, there is too broad of a chance that you'll have multiple people sort of covered by the same one, but something as unique as an email address or a telephone number that the consumer will be able to demonstrate through multi-factor authentication that it is truly their sort of account, their email address that they have control over. It's something we feel is a reliable indicator that you've matched to that consumer and therefore you should delete their information. And Mr. Kemp did mention to me just now, and a good reminder, name is also something you can put multiple of. So we recognize people who have nicknames or multiple spellings of their names. People will change their names. And so you'll be able to enter multiple names as well, just to try to account for that situation.
Everybody misspells my last name, so I could actually put how people often will spell it, like they'll drop an A or something like that.
That's exactly right. Yeah, capitalize something or yeah, exactly.
Thank you. Good question. Mr. Lee, please continue. Oh, sorry, Mr. Worth, are you leaning forward with a question? Okay, go ahead. No? Okay.
The final modifications also include minor clarifying changes, such as website disclosure requirements, fee payment obligations, and status reporting, which we're happy to discuss as well. And that takes us to our prepared remarks, and we're happy to take any other questions you may have.
Wonderful. Mr. Worth.
Thank you. So I consumer registers. Hopefully there's a match. How do I know if there is or isn't?
So it's going to be great. Well, first of all, we will say I look forward to being able to demonstrate this for all of you, hopefully before the end of the year, in fact. But in short, there will be a status reporting function. You will be able to come back to the system at any time and come back to your profile, so to speak. See it now. We will, even because we're not storing plain text, we won't necessarily show all of your information. It'll be sort of a hashed version of it that you see. But you'll also see status of each data broker who is registered, what they've done with your information. And there'll be multiple categories. One will be pending because they only have to hit the system every 45 days. So as you can imagine, once you hit submit for up to 45 days, it'll be pending with most of the data brokers. But then at that stage, then they might report that they found a match and they deleted your personal information. They might report that they did not find a match. They don't have any record of you, or at least based on the information you provided. Or they might say that they made a match. However, all the information they hold is exempt under the law, and so therefore they didn't actually delete anything. And then the final one is they found multiple matches, matches that match to multiple consumers, in which case the obligation under the requirements is just to opt them out of sale or sharing instead of fully deleting that information.
So, I don't need to know who that audience is because you're going to provide every registered broker.
Exactly. You'll get that status for each broker.
How do we check that they really deleted?
Those are great questions too. I mean, so obviously that's something enforcement will care a lot about, but one of the things that's in the Delete Act that I'm sure Mr. Kemp can speak to much further than I can is there is an audit requirement that kicks in beginning in 2028 where, and by the way, I'll just preview now, I anticipate coming back before this board needing to do regulations on audits for data brokers for compliance with DROP. But they're supposed to engage under the law independent auditors every 3 years to ensure compliance with how the system works. So that'll something we'll be watching closely.
Mr. McTaggart.
So if you wouldn't mind just kind of explaining, so I'm in 7613. I'm on page 10 of 16. So I'm on the second page of 7613. And this is where it's 2A. And this is what I didn't really understand. So it says, all the insertion says you take all these different identifiers, you combine them into a single identifier and hash the combined identifier before comparing it to the consumer deletion list. So that was where I was kind of getting at. It implied that I took 17 pieces of information, came up with this very specific hash, which is only going to match if everything on the data brokers list is the same. And this is where I didn't understand what you were talking about, that you're going to do it just for the email and just, so there may be a different one. If you could explain that paragraph, because it does feel like you combined all the different identifiers into one hashed identifier for one single new identifier, and that felt.
Yeah, absolutely happy to take that question. So again, I want to start by saying we will be identifying before launch of the system for data brokers different sets of deletion lists. And one deletion list we anticipate will be email address only. So that'll be the whole value. Others, as I mentioned, though we recognize are not reliable as a standalone. So first and last name, others might share that first and last name. So we had to add others. In terms of the hashing, the issue, I'll tell you, is actually a technical one. And that is, we're not going to store information in plain text. We're hashing it as soon as a consumer puts it into our system as a privacy and a security measure that we're taking, which means then if a consumer comes in and adds information, so maybe changes a zip code, we actually, as the agency, couldn't go back. And you see the problem, the technical issue is it either all has to be hashed or none of it can be hashed for us to be able to create the combinations that can match to another database. So I recognize it's a little complex, but this is to say, we recognize for those multiple identifier lists, there'll be a little less forgiveness, so to speak, in terms of if there was possibly an error. But as long as everybody is standardizing and hashing their information in the same way, that shouldn't actually inhibit the ability of us to come across
And then, so that all makes sense. And then how do you guys plan to figure out, okay, is it working? Is the fact that everybody has one of the 27 boxes and it turns, I mean, you're making a lot of sense on just the email, but on the multiple ones, what's the process for evaluating?
Yeah, that's a really great question. I mean, again, we're still in deep construction mode right now, but I know one of the benefits of sort of the timeline of implementing this is data brokers actually don't have to start hitting the system until August 1st, even though consumers can start coming in as early as January 1st. So we actually anticipate a lot of testing. We're going to be kind of open doors to data brokers to start working with them. We are exploring options of even how we could offer potentially like sort of a hashing check tool or something of that nature so that, again, we can iron out these issues in advance of the law triggering.
Thank you. Other comments, questions? Once again, I want to commend the amazing legal division team for taking what I thought were some very helpful comments and of course what you now understand about the system as it develops, and so thoughtfully creating regulations that will guide data brokers and consumers and how they can use the system. So thank you for that. I will be asking for a motion because there are changes to the text. So the next step would be to send those out for public comment again. So we will be in a public comment period again, should the board agree to take this step. And the motion I'll be requesting is to direct staff to take all the steps necessary to prepare and notice modifications to the text of the proposed regulations for another comment period. The modifications shall reflect the changes proposed by staff in the written meeting materials for today. That's the motion that I will be requesting, and we might as well go ahead before we take public comment if anyone would like to make that motion.
Move.
Thank you. I have a motion. Do I have a second?
Second.
Thank you. I have a motion from Mr. McTaggart and a second from Dr. Noneke. And with that, Ms. Carwile, is there public comment?
This is on agenda item number 6, discussion and possible action on proposed regulations regarding automated decision-making technology, risk assessment, cybersecurity audits, insurance, and updates to existing regulations, including possible adoption and modification of text. Okay, so I apologize, but this is agenda item, again, number 6, discussion and possible action on proposed amendments to regulation sections 7601, 7604, and adoption of regulation sections 7610 through 7622, implementing the delete request and opt-out platform requirements, including possible adoption or modification of text. Now, if you'd like to make a public comment on that, please raise your hand by using the raised hand feature on Zoom or *9 if you're joining us by phone. Madam Chair, I don't see any comments at this time.
Thank you very much. And again, thank you to everyone for the excellent work to implement the Delete Act. We have a motion on the table. Ms. Carwile, would you please conduct the vote?
Certainly. Board Liebert?
I'm not bored.
Oh, I'm so sorry.
That's okay.
Board Member Liebert?
I'm just teasing you. Yes, aye.
Board Member McTaggart?
Aye.
Board Member Nonecki?
Aye.
Board Member Worth?
Aye.
And Chair Urban?
Aye.
Madam Chair, you have 5 yeses.
Thank you. The motion carries with a vote of 5-0. And we will wait for staff's next report on the comments that we receive on the wonderful revisions that are before us. We will now turn to agenda item number 7, public comment on items not on the agenda. I'm pleased to handle this item. This is the item I previewed at the top of the meeting, during which members of the public only may raise comments or make comments on items that are not on the agenda for today. As a reminder, the board may not discuss or act on any matter raised during this public comment section. So if we appear to be quiet, we are listening to you, but we can't take action in order to fulfill both your goals and the goals of the board. Ms. Carwile, are there any public comments on this agenda item?
This is agenda item number 7, public comment on items not on the agenda. Please raise your hand using the raised hand feature if you're joining us by Zoom, or *9 if you are joining us by phone. Madam Chair, I'm not seeing any comment at this time.
Thank you very much. With that, we will move to agenda item number 8, which is our item for future agenda items, discussion of future agenda items. In addition to items upcoming on the regularized calendar, I have a number of items on my running list. And I also understand there have been a request to discuss the meeting schedule again. So we will do that. But just to preview, the running list includes administrative update. Actually, we did the administrative update today. We're ahead of the game today. That would be on the regularized calendar later generally. On the budget priorities and plan, we also did that today with Ms. Chidambira, but there may be updates in response to board questions today. So that may come back before us. Our annual enforcement report and priorities from Deputy Director Mako is anticipated for our next meeting. Our regulations priorities discussion, during which the board discusses priorities for future regulations package. We held that over because we have been very actively working on existing packages, and that's been held till the last meeting of the year. Mr. McTaggart has requested consideration for rulemaking that might change the right to delete to partial deletion. I know I say it every time, it's just so I make sure that I don't forget. We have also been periodically bringing up GDP adequacy under the General Data Protection Regulation in Europe, and our current plan is when it fits well into the schedule and there's information that we might get a briefing from the European side on the requirements for that. Mr. Worth had required to hear about comments from the data broker industry as regulations move forward. They've continued to move forward, and I would welcome further, if there are further comments he would like to hear, to put those down on the list. And Mr. Worth also brought up, I think, a really important topic, which is a discussion of small businesses and the extent of our jurisdiction, who's actually covered by our law. Mr. Liebert has helpfully brought up the wish for informational sessions for the board on topics that will help edify us in the business before us. In light of comments today, and comments throughout, actually, I will put for myself, in line with what similar to what Mr. Worth suggested, is an understanding of how our law, which is unique in its application to employees, applies to employees at some point in the fullness of time when we are ready for it. We will have a report from the rulemaking process subcommittee when there's time for it. And then on our regular quarterly meeting on November 7th, we have, as well as the regulation priorities, we have annual legislation proposals and priorities. So we've been talking about our views on the legislature's work for this session, and that will be proposals and priorities, if any, for the next session, and our annual intergovernmental affairs update and priorities. We had a lengthy discussion in December about this year's meetings, and we gathered some dates for quarterly meetings and holds in case of need, which resulted in the regularized schedule on our meeting page on our website, as well as some hold dates. I believe that there's a need to discuss adjusting that schedule, and I'm not quite sure to whom I should hand this over. Okay, thank you, Mr. Kemp. Deputy Executive Director, Ms. Garcia.
Board. So yes, in terms of recommendations for the next meeting, September, we did hold 2 dates, both September 4th and 5th, but just given timelines with the 15-day comment and staff preparing adequate materials, we would recommend meeting on September 26th, if that worked for the board. And again, based on schedules that I've received from some board members to date.
September 26th.
Correct. And that would be in San Francisco at the CPUC facility. And that is a Friday.
Okay. Works for me? Okay. Mr. Liebert? Okay, Mr. Worth? Deal, Ms. Garcia.
Wonderful. So then just to confirm, to go through the rest of the year, we also have November then held for our regularly scheduled board meeting. Does that work? It is November 7th, the Friday.
I think it works for everyone but me, so I'm trying to make it work.
Oh, okay. So you will let the executive director know.
I will talk with Mr. Kemp, yeah. Okay.
And then just to confirm, that location will be San Francisco as well.
Okay. And I understand that for next year, and maybe we can talk about this in our last meeting of the year as well, we plan to endeavor to add Southern California location, which I certainly support. Okay. Wonderful. Thank you all very much. So I just zoomed right through that without asking for further agenda items from other board members. Does anyone have anything they'd like to add to the list or propose? Okay, hearing none. Ms. Carwile, is there public comment on this item?
If you'd like to make a comment or on agenda item 8, future agenda items, please raise your hand using the raised hand feature if you're joining us by Zoom or by phone using *9. Madam Chair, I'm not seeing any comments at this time.
Thank you very much, Ms. Carwile. In that case, we will move to, we've already taken closed session out of order. That was agenda item number 9, which brings us to agenda item number 10, adjournment, our final item. I'd like to thank everyone, the board members, staff, and members of the public for all of your contributions to the meeting, and of course, contributions to the work of the agency we discussed in this meeting, and to the board's work. May I have a motion to adjourn the meeting?
So moved.
Thank you. I have a motion from Dr. Nanaki and a second from Mr. Liebert, although for a second I thought people did not want to end the meeting and would like to just keep meeting. Ms. Carwile, could you please conduct the vote?
Yes, this is a motion to adjourn. Board Member Liebert?
Absolutely.
Board Member McTaggart?
Aye.
Board Member Nanaki?
Aye.
Board Member Worth?
Aye.
Chair Urban?
Aye.
Madam Chair, you have 5 yeses to adjourn.
Thank you very much. The motion carries with a vote of 5-0, and this meeting of the California Privacy Protection Agency Board stands adjourned. Thank you all very much.